In agreeing in the meaning of costumes. The rapporteur was reflecting that this is an element, costume, that must be built in procedures or norms from the indigenous people. By saying this, I would like to specify that the whole event is based in three pillars, elemental pillars. The first one, as you've seen, it is the recovery of good practices. The second one, to identify obstacles and critical areas. And the third one, action in some lines that will allow us access to justice for indigenous people. Now, the tables have been developed in these three alignments. For instance, the first block for coordination between systems on the first table had the recognition, constitutional recognition of originary indigenous constitution. The second table, in the same coordination sense, had the elements of the due process and respect to justice, indigenous justice. Now, the third table of this block of systems coordination consisted in the articulation of the originary indigenous system and the ordinary system and human rights. In this first block, we can highlight some elements. For instance, the fact that originary indigenous jurisprudence in some processes and some spaces is still being rebuilt, in the reconstitution of the historical memory, the recovery of their own systems, and in other communities, these systems have already been consolidated. After the first block, we have an intermediate meeting, and we had the opportunity to reflect upon the role of the fellows, the scholars, and the High Commission Office. And the scholars were sharing that it is fundamental to work on the field. It is of extreme importance the strengthening and the reflection from the nations and indigenous people, having indigenous organization on the decolonization. Afterwards, in the afternoon, we've had a beginning with a keynote lecture, in this point related to territory and access to justice. The rapporteur invited us to reflect upon good practices, specifically some countries that develop themselves even with indigenous justice with a lot of budget. And in some cases, they even have indigenous judges performing, operativizing the administration of indigenous justice. In the afternoon, we also had to work with the block of law, right to territory and justice. Likewise, this has developed a first table with impacts of business and in the environment. The second table talked about the challenges of territorial demarcation, and the third table the use of justice system, ordinary justice system as a demarcation element when thinking about the rights to land and territory. So in this table we can highlight the position of the ILO, 8.5% in Latin America, when thinking about the population, identifies themselves as indigenous people. Another key percentage is that 30% of this population has poverty conditions. Is in that level. Another data important to mention is that 52% of indigenous people are in urban areas. Another key element in the territorial demarcation process is discrimination and inequality conditions. In the plenary sessions, in those lectures, they were given as an example that the states, the governments, ask indigenous people for them to have maps, technical tools, and so on. But indigenous people can't even have access to GPS to identify their territories. And the state, with all of their devices, well, they have all of these conditions, and they delimit, they demarcate, prioritizing the state's lands with tax purposes and so on. We finished the session with reflections from two plenary sessions that were very important, that aim, once again, to three main pillars in this event. Each one of us must take the good practices to identify obstacle and critical barriers, and finally, to identify some action lines. So what is our role today? Just like yesterday's session, we will start with a keynote speech with access to justice. This time, speaking about the advocates, environmental defenders, and indigenous advocates. So we will have a block this morning. We'll have a first table on the situation of the risks and threats, vulneration of rights of indigenous authorities and the advocates of the environment. The second table will be speaking about access to justice, environmental justice, and the defense of the environment. The third table, reflecting upon the role of protection mechanisms in the system of the United Nations and the American system, or inter-American system. We will finish with a closing dialogue that will be specifically identifying the roles of the system for the protection of the rights of the nations and indigenous people, but also the defenders of the environment. And as a key tool, a key element on this event, we will read a document on those three elements that I have been doing reference to. So what are the commitments that each one of us have on good practices, obstacles, critical barriers, and what are the action lines that we take from this dialogue? So that's the summary of yesterday's session in a very concrete way. Hopefully, I have taken the key elements of the tables. And now we will have the keynote speech, Access to Justice in the case of an attack, murder, criminalization of people, defenders of the indigenous, the environment, and the resources. For that, I will call upon Mr. John Jaraf. Hopefully I pronounced the names correctly, because I'm really bad for English, I'm sorry. And also, we will have in the table Ms. Antonia Urrejola, please. So this session will be moderated. It's a session moderated by Mr. John Jaraf. Good morning to all of you. It is a great pleasure to be here with all of you and with our dear Antonio Rejola, that probably many of you don't even need to present. Antonia has a great trajectory in the advocacy of human rights in general and the defense of the rights of the indigenous people, specifically a recognized international expert in this area, studying law in the University of Chile with a PhD in human rights and democratization processes. She also worked in the Ministry of Planning and Cooperation and advisor in issues related to indigenous people. So in her trajectory, she highlights her work in the Inter-American Commission of Human Rights as a commissioner and president of the Inter-American Commission. It was also the first Minister of Foreign Affairs in this current government in Chile, and also a consultant of different international organisms such as PNUD, ILO, and ACNUD. So the High Commission a more human focus. So Antonia, please. Good morning, everyone. Familiar faces, dear friends. It's such a pleasure to be here with you today. The topic that I'm going to be speaking about is related to access to justice when thinking about the defenders of the environment and indigenous people. I know yesterday you talked about issues related to rights in territories. It's impossible to speak about access to justice in environmental advocates with indigenous people in the territory without talking about what are the standards of access to the rights of indigenous people. It's very connected to that. Of course, I'm not going to stop on that, but I do think it's important to point out that according to the standards, the lack of warranties on behalf of the state of the rights of indigenous people and tribes to live in their ancestral territories might imply to submit that to substitution of extreme lack of protection. This is what we see with the environmental defenders on the territories and the indigenous people. And from that perspective, it is key to insist in the obligations that the states have to guarantee rights of indigenous people in collective property. And that is an obligation that the states have, which is highly connected to the need for the states to adopt legal and administrative measurements that are necessary in order to create effective mechanisms. I highlight the effective in terms of limitation and demarcation of territories, conformity with the legal rights, but also this obligation of the states also implies for the states have the obligation to prevent the occurrence of conflicts with third parties due to the property of the indigenous people. Conflicts regarding third parties, especially companies, and that part of the situation on the territories and the environment. The states have also the obligation to respect collective property and a correlative obligation to prevent the colonization of the indigenous territory on behalf of other people. Now, in the inter-American system, I work in the Commission with indigenous people. There are many cases connected to the right of indigenous people with collective property, especially this obligation that the states have to establish measurements of demarcation and limitations that are effective in a reasonable time. I mentioned two cases with the court, the Chucuro people of Brazil and the case of Yancajonas from Argentina. In both cases, the Brazilian state and the Argentinian state were condemned for not having, in the Brazilian case, the delay, having demarcation systems that were not effective mechanisms, a delay of over 26 years for the recognition of the lands of that people, and in the case of Argentina, the lack of the inexistency of mechanisms, not only the obligation of having mechanisms for the limitation, but also those mechanisms must be effective. In the case of Argentina, those mechanisms did not exist. In Brazil, they were not effective. I mentioned two cases. There are many more. I think it's important to start with this introduction with speaking about the advocates, the defenders of the environment and indigenous peoples' territories, because it is connected with access to territory and the protection of territory and natural resources. And also because the issue of territory is one of the key elements when speaking about defining coordination between national justice and indigenous justice, the territory, therefore highly related to the topics you talked about yesterday. So to go straight to the advocate concept on human rights in general, the United Nations systems and the Inter-American system have defined what is understood by people that defend the human rights. What's been established by the standards is that we're speaking about people, whether individual or collective, that acts to promote, protect, and the performance of human rights and the key freedoms in the local planes, national planes, regional planes, or international planes.
This concept of defenders of human rights comprises professional activities and also a lot of people who have an occasional sort of link with the defense of human rights. In other words, they don't have to dedicate themselves to the defense of human rights to consider themselves as. It may be occasional through a concrete case where many people may be from the murder of their family members, maybe they turn occasionally for terrible things that have happened, they turn into defenders of human rights. The concept includes, and this is also important for carers of justice, because they contribute to access to justice as well, whether it be through the representation of victims, through investigation, sanctions, and reparation of a violation in particular, or enforcing justice impartially. I'd like to mention that. They carry out certain honor to the role that they have is to exert justice independent and impartially. We must understand the justice operators are also defenders of human rights. In the current context that we're seeing within the region of persecutions to independent operators, I believe, you know these examples better than I imagine, but it's important to mention nevertheless that the defenders, operators of justice also are defenders of human rights and also independent journalists with their role. So according to standards, defenders of human rights may be any person, never mind their gender, age, or where they come from. The main criteria is the activity that they carry out. They must have any influence on any other they must not receive payment or belong to a civil organization to be considered as a defender of human rights. According to the standards, nevertheless, the concept of defender of human rights is a concept which is pretty broad, nevertheless flexible due to its nature, and therefore it's important that the states, we will see further on in fact, that the states, when they set regulations or protocols and matters of public policies related with defenders of human rights, they must take notice to this broader sense. What we see is more discussion lies is when the states limit the understanding who are the defenders of human rights or don't understand well. So this has direct implications with the threats, investigations, and the measures of protections regarding defenders. So the importance of defenders of human rights is that they contribute to eliminate effectively the violations to the human rights and freedom and fundamental freedoms, and to improve the social conditions, political and economic conditions. Also, the Inter-American Commission of Human Rights have pointed out that the people, defenders of human rights, are an important piece for the construction of a democratic society, solid and durable, due to their role. So when we request human rights, when defenders are affected, democracy is affected. So what we see when we see countries where there's a systematic persecution of defenders of human rights, we also see a group of other democratic obstacles very much linked with the democratic guarantee. The United Nations and the Inter-American system have talked about the right to defend rights. Due to the importance that activities that the defenders carry out, the Declaration on Defenders of the United Nations establishes that any person has the right, individual or collective, to promote, to seek protection and realize human rights and fundamental rights in the local, national, international plane. Starting from this recognition by the General Assembly of the United Nations through the Declaration on Defenders of the Human Rights, the right to defend rights has also been recognized within regional systems of protections of human rights. And there, the Inter-American system has recognized the exercise of right to defend human rights, identifying it as the possibility to promote and defend freely and effectively any type of right whose acceptance is fundamental. Those contained in the Declaration of Defenders also, and the Inter-American system mentions also the new rights or components of rights which is still being worded or discussed. This is very important because if it was not included, the right to defend rights and the concept of defenders to be able to promote rights under discussion, how can we progress recognizing new rights? So therefore, not only are we talking about defending fundamental rights that are in different agreements and treaties, if not those that are under discussion as well. Because that's how we progress, of course. So it's very important to set and establish this criteria. Now, the current context of people, of the defenders of human rights, before they reach access to justice, it's important to mention this. You know very much better than I the situations. Many of you are defenders. However, I would like to mention that, generally speaking, as we see, especially in the region, the risks that they face vary depending on the context of each nation, the methods employed regarding the threats, possible perpetrators, the degree of impunity of these investigations, the type of defense and geographical location of peoples. Of course, then in Latin America, the defenders face acts of violence, acts of crime against defenders through the undue use of penal access and official pronouncements that affect the legitimacy of the labor of defending human rights. In the case of indigenous communities, what we see more here cases is when defenders opposed to mega projects or other external economic activities in their territory. We see takeovers, attacks, threats, constant harassment on part of security agents. There's another issue as well. The Sarayaku people versus Ecuador, the state of Ecuador, where mainly it's linked to territory and the role of agents of private security regarding a mega project there. And the violence on the Sarayaku people by the state, inefficiency of the state. Verbal harassment, gunshots, or gunshots against the community. The Inter-American Commission, here we're with a colleague from Brazil, in fact. We visited, Miguel Mesquita is here also, when we visited the country. In the Inter-American Commission itself was attacked by gunshots, visiting an indigenous community. I remember, Miguel, you were there, right? I wasn't there. Nevertheless, I was Mato Grosso do Sul. But in a visit to indigenous community, imagine that, the Inter-American Commission, they faced gunshots and threats from landowners. Imagine the situation of those communities when the Commission or Inter-American Commission of Rights is not present. Destruction of households and of the crops, destruction of bridges, even the only way of linking different cities or villages through the media, process of criminalization, the due use of criminal rights to criminalize the acts of manifestations and protests on a social level of indigenous communities, applying different processes such as usurpation, instigation, crimes related to terrorism against safety of the state, invasion of private property, illicit association, many things. So here in Chile, we're seeing an allure of usurpation clearly will have an affectation on indigenous peoples and their claims regarding their territorial rights. Criminalization, of course, favors the stigma of the process of defense of indigenous peoples. These are mentioned as called terrorists, criminal groups, destabilize of democracy and of public order. In Chile, we have a specific case or emblematic case, which you know of Norinca Trimán versus Chile, with the application precisely of the anti-terrorist law, in this case to Mapuche leaders. The court determined that the application of the anti-terrorist law violated the presumption of innocence and the state obligation to define the collective behaviors with clarity and precisely. And the Inter-American Court said that the judicial issues that condemned the victim contained prejudice against the Mapuche people, violating the principle of non-discrimination and equality. Examples, we have seen this throughout the whole region. Yesterday, we saw the persecution to Paz Indígena in Ecuador. In Ecuador, there was a level of amnesty implied there. Or what happens in Peru. Raquel Inigoyen was there also. Who was in this area of Tres Islas. There's criminalization on them. I don't know if Raquel's here. So the figures here, very quickly, the Inter-American Commission has denounced the murder of 126 people, defenders of human rights. In 2022, mentioning that the major number of these murders, the majority were precisely regarding indigenous defenders, Afro-descendants, environmental defenders, and territorial defenders. So the United Nations Defenders Declaration points out that the official statistics on the number of defenders of human rights murdered each year are limited at a national level, but this has a direct relation with what I was mentioning just now. That is, how states, through their different regulations and protocol, define who are defenders. When that definition is limited, obviously statistics on the threats of defenders are not realistic. So we could have to see the focus is on the investigations carried out on the threats and murders as well. Obviously, there's little information at a national level on the murders of defenders, and less information, even so, on the threats to defenders, who, generally speaking, are before, but these things happen before murders. Now, the attacks generally are produced in a context of violence and structural inequality in societies in conflict and patriarchal communities. Murders and threats generally are produced when there is a context of negativity created around defenders, and generally speaking, or related to concrete defenders. Obviously, this makes them more vulnerable to these attacks. The rapporteur mentions that if the way was modified, how political leaders and the public perceive and mention of the value of the labor, the task of defenders, and saw the positive side of these towards the society, maybe they will reduce the risk of them being attacked. So therefore, we urge that the state design measures of policy and policies to protect defenders of human rights, to include, first of all, the investigation of threats, not only investigation already of injuries, harm, or murders. It's clear that not all threats on death threats end with murders, as not all murders there was threats before these murders, so generally speaking, there is a correlation. Now, the report mentions that the defenders of human rights who work in determinate spheres are vulnerable to the attacks, and amongst them we have the defenders related to the defense on the environment, defense to lands and indigenous territories, and Afro-descendants as well, and who are opposed to mega projects within these territories with previous consent, free and informed consent. That's why, therefore, the importance, as I mentioned at the beginning, regarding the guarantees that the states must deliver regarding states and territories. From 2015 to 2019, the Office of the High Commission of Human Rights recorded also 1,323 murders of defenders of human rights, from which 165 were women and 22 underaged. Throughout the period in Latin America and the Caribbean, the High Commission mentions, recorded constantly the major number or the majority of numbers of defenders, 133 defenders from 1,323 are from Latin America and the Caribbean. So who's leading this is Colombia, then Brazil, Mexico, Honduras, Guatemala, Peru, Nicaragua, Venezuela, and other countries also. There is a non-governmental organization, an NGO, has carried out a global witness who's carried out some work during the past years. It mentions that during the last 10 years, between 2012 and 2021, mentions about the murder of 1,733 people, defenders of the earth and the environment. And the majority of these murders, 68% of them, are concentrated once again within our region. So from these, the 68%, 39% of this are attacks directed to defenders of the indigenous populations, indigenous people. So it truly is an extremely high figure. From the 7 out of 10 countries with a majority of number of murders of defenders of the environment and the land, 2021, 12 and 2021 are Latin Americas. In 2021, 200 people, defenders of the environment and the land, were murdered, and during that time Mexico was leading these murders, Brazil and Colombia. Amongst these three countries, they represent more than half of the attacks recorded around the world during 2021. So Global Witness also recorded something which has happened during the last couple of years, which also are mass murders, such as what happened in Mexico, or the massacre of 15 indigenous people, defenders of the rights of the Mestizo people in Nicaragua. So from this figure, it's important to point out also that 1 out of every 10 defenders murdered around the world in 2021 were women, nearly 2/3 which also were indigenous. And here the issue, of course, of the violence of gender, which is very much in vogue within the region, is important to mention. Now, what are the general standards regarding defenders of human rights? I will mention these, and then just to refer myself to access to justice. One is the obligation that states have to respect the rights of people defenders, such as a measure to mitigate the risks that they face, and therefore, for example, avoid stigmatizing narratives and of defenders. And secondly, the obligation not only of respecting the exercise of the right to defend rights, if not to take prevention measures as well, to mitigate the risks of defenders. Here we see a lot of issues regarding the measures of prevention, especially the focus of gender and indigenous as well, and the measures of protection. Then we see the obligation of protecting measures to mitigate also the risk for people, and also finally the obligation to investigate, judge and sanction crimes carried out against defenders to mitigate therefore risks. It's undoubtable that there is a direct relation between investigation, diligent and effective investigation of the risks and facts to mitigate the risk therefore that defenders face. Now, the will of state to reduce the levels of impunity on the crimes committed against defenders is fundamental. And what we see that exists in general, there's a lack of political will to investigate. So therefore, it's necessary that states remove de facto and de jure all obstacles that make the impunity remain. It exists when once the responsibles are condemned within the framework of an investigation, the truth of the facts of the truth are not clear. Impunity represents an obstacle for the defense of human rights, and it has a threatening effect within the society, which obviously weakens the labor of defense of the defenders. The state must pay special attention to investigations on threats directed to defenders. This obligation to investigate is reinforced, therefore, the obligation that they have, generally speaking, the states to investigate violations of human rights must be reinforced when we're talking about defenders of human rights, due to the importance that they have, as I was mentioning now, regarding the role that they have within a democratic society. And from that point of view, it's fundamental also that the lines of investigation, when we're talking about threats or murders to defenders, they must be broad, and therefore the first hypothesis must be that these threats and murders are related with the labor that these people exert. What we generally see is that investigations that carry out the states investigate such as like a normal felony or just a robbery and not real role that exerts. It's fundamental that from the beginning of investigation, when we're talking about a defender, the state really investigates properly, thoroughly, where the hypothesis is that the threat or the murder was precisely due to their labor. And therefore, the due diligence that the state must carry out within their investigations regarding defenders of human rights is related to this hypothesis, which is broad and thorough with investigations. We must take into account the context, which is fundamental, and something which is important that we see in the region. We don't only should investigate the material authors, as we see in Honduras, if not with the case of Berta Cáceres, if not also the intellectual authors. Usually they are not judged, or those who financed or funded this, who's behind all this. This is important when we talk about territory and the mega projects, when we talk about, when we see that large part of the murdered defenders in the region are related to defense of territories, where there are mega projects present, and therefore, who could be behind all these are the large companies. So that's why it's necessary that investigations ask themselves who wins with the murder or threats, or who's behind all this, because the only way of avoiding the risk for the role that defenders exert is to see who's behind all this. If not, we don't regard the context or who's behind all this, well, who will continue their task will be threatened, and then this will continue non-stop. So we need a differentiated sort of investigation, impartial on gender and many other issues. Therefore, that's it really. That's on the investigations on this. Now, to finish my words, one asks themselves, what makes the attacks against people, defenders, especially of the environment and the land, what makes it possible? I mean, why the level of murder and threats is higher regarding these people, defenders of human rights, and not others? Now, the causes are many. Nevertheless, of course, within the region we see the main issue is inequality in the distribution of lands, recognition of the rights of indigenous peoples regarding their territories, corruption, state and companies, and the whole issue of corruption, reduction of civic space, where more threats are, murders and harassment happens. It's usually where there is a reduction of civic space. For example, we see these in Central America. And also when we witness a high degree of impunity and the lack of independence of the investigators, operators of justice, and also the entrepreneurial business impunity. So just wanted to point out the importance also, when we're talking about mitigation and protection of defenders of human rights, fundamentally the land, territories and the environment, it's fundamental or crucial, the due diligence of companies as well, and the obligation that they have, not only states, but also companies, industries, according to the principles of the United Nations of taking preventive measures to take charge when the territories and the projects there are murders. They must take charge or become part of the investigation, because companies also have a responsibility regarding the role of defenders of human rights. I would say that those are the main topics here, and as a conclusion, nevertheless, I would say that impunity regarding threats, harassment, and murders of defenders of human rights, and concretely of indigenous peoples, the land, and the environment, the Achilles heel is this issue of impunity. The impunity is very high, and as there continue being impunities, that's the signal of states, is that there's no issue, and they'll continue murdering defenders of human rights. These things will continue happening. That impunity is related intimately with the concept of states. What is understood as defenders of human rights, when that concept is limited, that leaves a lot of people out, so therefore the measures of protection are not for the whole of people who dedicate to defenders of human rights. Also, when they're not, the investigation are not regarding the activity of the person, if not like they're treated like a common crime, or when investigations do not persecute the intellectual authors. It generates an environment of impunity and therefore high figures of murders that I have been referring to. Thank you very much for this summary, Antonia. Very concerning, nevertheless, about the situation here. We can maybe open the floor here to the audience. I'm very much aware of the time, but please, if you have any comments, questions. What Antonia has just summarized, of course, many questions have risen, I'm sure. As a moderator, of course, I have many questions, but I will give the floor to the audience. There's the first question.
Buenos días.
Good morning. This is greetings in my Elvaniva from the Arahuaco people from the Venezuelan Amazon region. Those who do not know me, I'm Darlene Garcia from the organizing Young People of the United Nations, or the Youth of the United Nations. Very interesting, the topic here, because I've worked very much with young people. And my question is, what is the recommendations that you would give to young people, we who are part of the struggle for our territories? I am mentioning this because we, young indigenous peoples, always regard human rights in Venezuela. We are aware of the cases that have happened in the north and south of Venezuela. What do you recommend to continue in this fight for human rights, which truly is a very complicated journey? Even though we do have laws, a constitution, indigenous as well, indigenous law in Venezuela, nevertheless we have a long journey to go as young people, and I would like to understand or know the recommendations to continue forward. And the state does not regard us as a threat, if not indigenous peoples who wish to contribute solutions to our territory, and that the debt, within this case, of the state, territorial delimitation is what we're fighting for in all territories, indigenous territories of our country. Okay, very well. So 3 or 4 more questions, and then Antonia will answer to these. Good morning. Thank you very much. I come from Mexico, and I agree with this issue of autonomy of investigation entities, in this case, the Prosecutor's Office of Mexico. We did not achieve in the case of disappearances, of murders of defenders, that these are really considered on the first line of investigation as defenders of human rights. Now, my question is, how can we use these international mechanisms, these international instances, to be able to encounter the prosecutors? In Mexico, this prosecutor's office is autonomous, so it's positive, but there's no sort of instance there, or state instance, which can dictate it, so it isolates it from us, and the situations of impunity is just increasing. So we cannot exercise our labor of defending human rights due to all the reasons that you have mentioned yourself even. That's it. Thank you. Good morning. I am Daki Lema from the university. And it seems interesting, the presentation. I think that the indigenous authorities are continuously involved in promoting human rights. But in those states where the legal pluralism is recognized, such as in the case of Ecuador, many times the adopted resolutions are also object to criminalizations. In this sense, my question would be, what mechanisms of human rights can actually be affected for the indigenous communities which have been criminalized due to the exercise of their own jurisdiction? Well, we have a question on recommendations to the young people, autonomy of a prosecutor's office as they are understood as the lack of response from their behalf to the need. And the third, on the tutorship of authorities of indigenous communities when they make decisions and they are criminalized for their decisions. Well, I don't know who am I to give any recommendations. Nevertheless, I believe that the first thing is to generate networks and to be in spaces such as these. I believe it's fundamental to generate networks, what indigenous populations, what they live in, what country is not isolated from what others are undergoing. So networks strengthens, and also it makes it possible exchange experiences, to exchange ways of incidences within the countries, and also to be able to mention before international organizations or entities the different situations which they're going through. The young people or indigenous peoples. It's not the same when specific communities mention something regarding violations of human rights when they're in comparison when there's a network, like in the Inter-American Commission of Human Rights, for example. There are thematical audiences. Many times there are thematical audiences where organizations, they meet from different countries, which allows to visibilize, therefore, a structural issue. And this is a way also to exert pressure on states, and so the system of protection can improve. The Inter-American Commission, in this case. I do believe that even though it's very difficult sometimes, I do believe that dialogue is fundamental, and one must try permanently to try, because sometimes there's no will, try to open spaces of dialogue with the decision makers within countries, whether it be the legislative, executive power, or the legal power, the judicial powers. Nevertheless, protest is fundamental. Nevertheless, dialogue is fundamental. Try to open up spaces of dialogue or discussion up to which is possible, and when there is will on the counterpart as well. And to use systems. In the case of Venezuela, unfortunately, they're not part of the Inter-American system. They're part of the United Nations, but permanent use of different platforms that the universal system or Inter-American system has available is fundamental. Nevertheless, networks are very important, and to be organized and not react alone. Now, how to use international mechanisms to encounter the prosecutors, for example. I was talking about the standards and methods of investigation. One of the flaws, which is regarded when we're talking about investigations or defenders of human rights, these have to do with the ability or skills of justice operators as well. I believe that there is an important topic here of being able to reach or to engage with the prosecutor's office so they understand the dimension on these threats and murders of defenders. The dimension which implies a broad investigation, a thorough investigation, all standards related to an investigation, that it must be exhaustive and expedite as well. What we see is that many times it's not just an issue about will, if not the lack of skills or training or abilities. That's the main issue. Training, I'd say. In fact, I'm sorry that I mentioned about the Inter-American system, even though this is United Nations, but this is what I know of, is the use of systematic audiences, because sometimes when there are thematical audiences, or a specific case, the Commission summons the state, and once the state is summoned, that's also the prosecutor's office. So to generate dialogue at a level of the Commission within an audience of a determined office is not the same, because we have the Commission in between there. So it's a bilateral instead of a bilateral dialogue. So to assess this, maybe the role of the prosecutor's office in the investigation can, maybe not just Mexico, but other countries, regarding defenders of human rights. Obviously, to use these instruments when there are specific cases, like the unfortunate case with Ayotzinapa. After everything, I believe that the use of the system of case is fundamental when the internal justice system does not respond. Mechanisms of human rights for indigenous authorities, for the tutorship of these. Well, in the case of Ecuador, I'm very familiarized with this because I was a rapporteur when that criminalization was actually given. I'm sorry to refer to the Inter-American system again, but I do believe that it's very important also, not only dialogue with authorities, what happened in Ecuador of the law of amnesty through the Congress. I believe it was the effect also of the pressure of indigenous organizations and of civil society before the Congress to request, to demand a law of amnesty, but also the judges, or the indigenous judges, the indigenous people who were criminalized and persecuted. I remember this in Colorado, I can't remember when. But this allowed also, then in the case of the Commission, they sent the state, letter on the state on the situation of persecution that these people were going through. Indigenous authorities were going through. When we talk about the universal system or the inter-american system of human rights, I believe that you don't have to use this just to denounce or accuse or for accusations, but for the universal system, and the inter-american system can be some sort of bridge when internal authorities are not listening to the indigenous authorities in this case. So it can react as an intermediary, because maybe if the rapporteur from the United Nations of Indigenous peoples are asking the state, for example, or as a middle person, or the state of the Commission, the rapporteur of indigenous populations as well. So therefore, I believe that we must remember that the universal system of inter-American system, and not just for accusations, but it's an intermediary as well before the states when complex situations are being carried out and internal authorities are not being heard. Just 3 more questions, please, because there's a lack of time here. So we have 3 questions. With this we finish, okay? Yeah, this experience is marvelous, which Antonia is telling us here. And we will request you to remain here so we can change the discussion, so we continue discussing here the dialogues in the hallways there. That's one of the virtues of being here in person. These conferences, that all questions that can be answered within these sessions or in a panel can be answered in the hallway. The 5 questions, please. As brief as possible, please. Good morning, ladies and gentlemen. I am Oscar Ayala. I am from the organization Tierra Viva in Paraguay. I wanted to ask a very general question. Somehow you answered in your last intervention, Antonia, on the currently impunity that exists in the region regarding defenders of human rights. It's very much associated to that characterization by the political sectors of the right wing, that defenders are a threat. They are considered as a threat by the right wing party. So that characterization, or that those policies of criminalization, persecution against defenders. Additionally to the context that we live, I'm talking about the southern cone here, where there are many currents of extreme right and left. So they have certain legitimacy, social legitimacy in their political discourse. So under that context, and regarding the protection of defenders of human rights, and due to your experience in the commission before the ministry here in Chile, what's the role of international organizations protecting defenders in this political context where at a social level, these currents tend to legitimate beyond the obligations of the state, criminalizations which exists? I'm from Guatemala. We in Guatemala, we're going through a very difficult situation, complicated situation, where we have been the indigenous peoples. We have given face to defend democracy. And we're sure also that many of ourselves who are leading this struggle, we will be criminalized. This is a denouncement against the presidents of 48 districts of this organization, which is called Foundation Against Terrorism. We call it Funda Terra. There's a denouncement against these people, an accusation against these people. What can we do to somehow protect ourselves against them? Good morning. Do you understand Portuguese, right? Dimba Tuxal, from the population of indigenous peoples of Brazil. I want to ask two questions. One, the situation that we're going through in Brazil, which is one of the countries that kill more defenders of human rights. We are sub-notification. We have cases of sub-notifications that the number for us, we within the territory, is much higher than that has been mentioned. So how can international organizations, are there any mechanisms to accompany the Inter-American Commissions? We're talking about sub-notifications here. Another questions are cautionary measures. We are not seeing the effectivity of the Brazilian state. In practice, we do not see the effectivity of the measures conceded by the Brazilian state. The Brazilian state does not comply. We deliver information to them, and unfortunately, we don't see the effectivity or the effect on how can we improve this system. That's the question. Good morning. I'm from the Chiripico Conivo people. I am an indigenous leader of an organization called Yama Apiari. This topic about criminalization is of utmost importance before the defenders of human rights of indigenous peoples. In my case, I have been persecuted last year for defending my territory, my people as well, my village. When we go out to protest and manifest or pronounce our voice, We are regarded like a pebble in in a shoe. That's what the state sees us as a so you know consider us like a bother. So I wanted to ask, what's the mechanism that we could have to organize ourselves, and what could guarantee this? Because it's not enough. Dialogue is not enough, or maybe informative workshops that we receive as part of the state. That's my question. Thank you. Good morning, Antonia. I'm Isabel Godoy from the Goya people. Um, my question is, regarding what you mentioned on the obligation of the state of preventing conflicts with third parties, like in the case of Argentina and Brazil, for example. But what happens with Chile? We have Huamalmacu case where it's militarized, criminalized the territory. In the north, it's less visible because we don't have any armed conflict. Nevertheless, they do exist. Yesterday, I mentioned the case of Tierra Amarilla, of this community there. So what does the Chilean state, with that obligation of preventing these conflicts with third parties, because they exist a lot in the south? Is there any other one last question? Two last questions. I will be moderator for the red table here, but it's very interesting. So, oh, they're going to show me the red card. That's it. But this is very important. We can actually hear the words of the former chair lady of the Inter-American Commission. In fact, we were requested to cooperate with the Inter-American Commission for this event, and that's what we're doing. You're carrying this out in person. Thank you very much. Good morning, ladies and gentlemen. I'm Mariana Jumbay from Ecuador. Well, effectively speaking, it is said that we should exhaust dialogue, right, with the states. In this case, in Ecuador, we have been going through 9 months under dialogue, sat down on the work tables. We reached certain agreements, around 215 agreements, from which 92 were related very much with the decision-making. Nevertheless, nothing has been fulfilled. So what do we do facing this reality? My other question is, in Ecuador also there has been many cases of brothers and sisters, indigenous and non-indigenous, that due to the struggle for human rights have lost their lives. Nevertheless, up to now, since 2019 and after in 2022, there has been no response. There's a total impunity there. What do we do facing that? Another thing, the defenders of nature, defenders of land and territory, due to their actions, have been processed by the legal system. And they're actually facing so many legal lawsuits and processes. Of course, the legal system reacts with an efficiency which is impressive in that case. Even so, the state, as such, reacts in defense and backs up, I would say, the large corporations, extractive corporations, because during the last, in the Ecuadorian case, they even have the military forces have backed the extractive companies and industries. So what do we do with this when there's evidence that there's no impartiality from the state itself? I mean, I'd like to mention that. Another thing, in the case of Ecuador, we have also seen that a structural racism has empowered itself. Our leaders cannot even pronounce themselves before all these violations of human rights, because immediately the media come there and the governors of the state, amongst other municipalities, they go in there and pronounce themselves that are extremely racist within the country. Those are my questions. Thank you. Good morning, ladies and gentlemen. I'm from Ecuador also. Effectively speaking, some uncertainties I had mentioned before, but I'd like to also mention, well, that during this, for a while now, things have happened in Ecuador. A consultation was developed regarding leaving the Block 43 underground. The consultation was won, and the government, the national government, manifested that they will not respect the consultation, the people's consultation, which was won. So in that sense, if the government is saying that they're not going to respect, but they say they do, but they respect the social struggles which are developed in Ecuador. So with a decree, under a decree, they start militarizing. And also the police. And they start exploiting the territory of the indigenous peoples, especially the mining industry. We presented a lawsuit to suspend, or a demand to suspend. We sent a lawsuit, a demand to the court, and the court suspended this. But it still happens. They continue exploiting. So therefore, we have hundreds of colleagues who keep struggling, but we're penalized. I know that there's some sort of a network, and this is more located in Argentina. I would have liked for them to be here, but I think it was impossible due to the fact that they are also fighting or struggling for the release of the social fighters who are imprisoned. And there has been no response, no answer. So I believe that from this summit, we should also support this network for the freedom of the social fighters who've been claiming at a level of all countries. Thank you very much. Okay, so I'm going to try to answer as fast as I can. There's not much time. Now, impunity and the role of international organisms. I believe that United Nations, in the face of the High Commission and the Rapporteur of Indigenous Peoples on one hand, and in the case of the Inter-American Commission, the courts themselves, even at one moment, they do what they can. Nevertheless, the truth is that I do believe that we have to continue pressuring. I mean, unfortunately, there are struggles that take a long time, and one has to do with impunities, and that the states can achieve. I can actually understand that to have a democratic society, the role of defenders of human rights, investigation regarding their threats, and sanctions are all linked. Unfortunately, I do believe that this subject, which a couple of years ago I would have been more optimistic, I believe that currently when we see what I was mentioning, because there's so much impunity, and one of the factors has to do with the corruption, another factor has to do with closure of civic space. What we're seeing in the region specifically is that's what's happening. Plus these the discourses of the right-wing, the extreme right-wing narrators who are gaining more power. So I think we have to react united, and that united has to do with organizations with different mechanisms of protection of human rights to therefore continue creating consciousness and awareness and denouncing and accusing making accusations. Unfortunately, we're in an era, because I could answer, well, what we could do is this, is more awareness, consciousness about the role of the defenders, the leaderships of ultra-right wings. But these are ultra-right-wing leaderships that base themselves against the protectors of human rights. Within the United Nations, they're all imperialist or communist, according to whoever says this, and that's actually hidden hard, because they say that the defenders are delinquents, are criminals. This is given roots, so I can't respond to this. Nevertheless, I do believe that we have to continue fighting for consciousness, and we have to continue fighting to create networks and generate especially education on this topic with these new generations of young people, to try to to quieten down these discourses. If one loses hope and leaves these discourses and these speeches to take the civic space, I think there we'll have decades. But there are no new generations that we have to educate. I think there is an important force there. That's why it's so important that young indigenous leaders are so important. I have no positive discourse at the moment to say about this, because this is very linked to the Agenda 2030. Republicans yesterday were talking about the good thing about this constitution that they're proposing is that it's against the Agenda 2030. You don't even understand. How can you be against the 2030 agenda? Because it's to improve the quality of life of citizens in general. But I believe that what we have to do here is constantly in all spaces, is to fight against those discourses. But it's difficult, especially with social networks. But we have to continue on that, I believe. Regarding Guatemala, well, first, solidarity with what you're going there, because I don't know how many weeks now you are striking there. I think Guatemala is an example of everything that we've been talking about. The closure of civil spaces, persecution to operators of justice, and all the ones that react according to, with the interest of the state. So I think that here, what you mentioned, the only thing I could say, plus we have somebody of the High Commission of Human Rights, is to see the possibility of a cautionary measures. Although denouncing these facts, denouncing in different spaces, that's what it comes to mind. Nevertheless, I want to give you my solidarity, because it's an example on how governments that reach our democratic governments start to erode democratic institutions. And I think Guatemala is an example of this. And when the international community that have reacted, they react late, because that's what's happened, unfortunately. Now, Brazil, one of the issues regarding the investigations and the protection measures, from the standards on measures of protections and obligations of states of preventing, well, one of the issues have to do with sub-notifications, the lack of statistics, disaggregated facts on threats and murders of defenders. That's an issue not just of Brazil, but if not of the whole region. The rapporteur of defenders mentioned it herself, how complicated it is to mention figures. The figures that I've given are not the real figures. We have to continue exerting pressure there so the states can have systems of information and disaggregated figures, which, I go back to the same topic, where the conceptualization of the defenders comply with the international standards, because there's a lot of sub-notifications. Many of these people threatened or even murdered are not recognized as defenders of human rights. So therefore, the first thing has to do with the fact that the states recognize the broader concept of this. That's why I talked about the concept of defenders of human rights. And the effectivity of cautionary measures, I know very well these sub-notifications that you mentioned in Brazil. I don't know what the situation is now with the change of government. Effectively speaking, with the government back then, with executive powers back then, was a dialogue of like talking to the wall. I don't know now if it's actually improved. Nevertheless, it is an issue, the effectivity of cautionary measures, especially when the states do not wish to comply. And therefore, new information is requested. It's just like a checklist. Without achieving effectivity or anything. Whereas in inter-American system, we can require provisional measures before the court when the state does not comply with the cautionary measure. The courts also have that possibility or that power, and even though the states, when they do not want to comply, no cautionary nor provisional measures are complied with. If there's more pressure, when the courts, through a provisional decree, or there's more pressure, a major visibilization as well of their situation that we're looking through, cautionary measures. It's the only thing that I could say.
Several asked information regarding. Well, I will speak in very much in general terms. I don't answer about the Chilean state. I'm not a chancellor. I can speak about Chile. When I was a commissioner, I couldn't speak about Chile. But yes, I do think that here in Chile there's a very severe situation. Speaking about the Mapuche thing, regarding guaranteeing the topic of third parties, we can speak a little bit more because they're hurrying me. They're telling me to hurry up. And the lack of compliance, I would like to connect the Chilean topic in general. They spoke about the queries, the consultation processes that are not respected by the state and the agreements that are not respected by the state. And I believe it is the main problem we have in the region. If you review what's been done in the region in different countries, I go to the Chilean case, the amount of commissions that have been performed, very good commissions have been performed in some cases. The main problem that the Chilean state has in Chile, in Ecuador, is not necessarily the fact that they don't sit on the table and have some dialogue, but the lack of compliance of the agreement. And that generates a lack of trust in the state, regardless of the government. And that is a topic that we need to be in charge of. I believe it's one of the main problems. And the human rights organisms from the Inter-American system and the United Nations systems can comply with the role of putting some pressure to comply with their roles. Sorry that I don't answer everybody, but we are out of time. Yes, we've extended our time. Thank you so much, Antonia. Thank you so much to all of you for your questions. Hopefully, we can answer some more on the whole. And what I want to say, on behalf of the Office of the High Commission, from the regional office for 6 countries from South America, we are also available for you. And I say this specifically when thinking about the colleagues from Ecuador. It is one of the countries that, as you know, has an office, and I have the honor of leading this office. So let's speak about this topic, because we publicly have signed this decree with the different bonds, with this environmental consultation process, and we're also very concerned that the government only recognizes the results of the whatever is suited for them, the plebiscite that suits them, and doesn't recognize everything. And so there is a lack of compliance of the results, very interesting results from the dialogues that our rapporteur Francisco Cari made a very nice, remarkable contribution trying to promote this dialogue. So let's speak then in the halls. And the office, of course, it's going to be receiving not only the complaints, but also acting in a dialogue with the authorities, even though in some cases it's very difficult. But that is what we're doing. Thank you so much, Mr. Jan Jaraf. So, right now, we finished the remote broadcasting. Please, all the attendees, consider the tables you have enrolled to. Table 1 is main risk situation, threats, and vulneration of people, defenders of indigenous people, and the current situation of the justice system. Table 2 is access to environmental justice and the defense of the environment. Table 3 is related with the role of the mechanisms of protection to the defenders, in this sense, in the same dynamic from yesterday, we ask you to go to the different tables. Thank you.
We will soon be beginning the next session. Once again, to thank and to greet everyone who's following us through the YouTube channel. We'd like to invite all rapporteurs of table number 1 who have developed very interesting rich discussions referring to the main risks, situations and threats and vulnerations of indigenous defenders, and the reaction of the justice system. Therefore, please, spokesperson of table number 1, please. Then after this, we invite the rapporteur of table number 2, or the spokesperson, who has mentioned very interestingly different experiences, especially on the access to justice, environmental justice, and defense for the environment. At the same time, we invite rapporteur of table number 3, who shared their criteria on the role of mechanisms of protection of defenders with investigation, rendering of account, and access to justice. Spokesperson of table number 3, Takilema. Also, we'd like to invite Indira Diaz from the High Commissioner of Human Rights in Honduras. So please come to the panel. Dear friends, it's important also to hear the conclusions of different tables. Please, you have the floor, Indira. I'm sorry, can't hear. Thank you for joining us here and on this today for productive discussions given on each table here regarding all the issues mentioned today. So remember that within the framework of the 75th anniversary of the Universal Declaration here, this place has been organized to identify best practices and to recognize this existing gaps regarding the exercise of rights of indigenous peoples, particularly the exercise of the right to access of justice. Access to justice. Through this dialogue, we seek to identify, therefore, the best practices or lines of action which can improve the actions of the state, focusing especially on justice. We understand that's an important challenge. Nevertheless, it's an excellent opportunity here. and a huge responsibility for the progress of rights of indigenous peoples. Remember that block number 3 talked about access to justice in the case of attacks, murders, and criminalization of defenders of the environment, territories, and resources. Therefore, we progressed. Well, we continue with the summary of table number 1, which was focused on the main situations of risk, threats, violations of peoples, defenders of indigenous peoples and defenders, and the actions of the justice system. Therefore, Judge Maria Alicia Quesada from Honduras will summarize the matter in discussion. Good morning. Thank you very much. I'm going to try to not to get a yellow or red card. Well, first of all, there were representatives of 4 countries, each exposed different situations, but at the hand they have certain similarities. The first was from Mexico, and even though their country has adopted the treaties, agreements, national laws and international laws being applied, this does not mean that the state has complied with these. In fact, even though it is said that the right of free and informed consultation, there's the right of that, right to water, traditions, territory, the state has not complied satisfactorily with these decisions adopted. Also, in 2014 and 22, there have been 148 murders of defenders and 582. These are indigenous peoples. There are more data, nevertheless, they're not accounted for because they didn't share that information. Now, the government does not protect the indigenous population. If not, they harass them and attack them. And also, we have drug smuggling and organized crime. So the cartels are also operating within the indigenous territories, which even they have filtered in organizations that defend human rights as well. So they're implementing mega projects like Interoceanic Channel and others. So beyond progress, these are damaging severely not only the environment, but the territory, the land of all the indigenous peoples. And the government is protecting these businesses. They have colluded also with a drug smuggler and organized crime. And something never seen before, the army is acting as a mediator within these dialogues, which truly is no sign of trust, if not of fear. In fact, she feels threatened walking down the street, and she feels that every day. The second panelist was from Canada, who explained the case that in Canada, in 2016, she was condemned for discrimination and protecting services for children and family, indigenous families, where more than 150,000 children were murdered or separated from their families. She talked to us about the obstacles that they had to have access to this sort of justice. The main one was the huge disparity existed between the state of Canada and organizations which defended these. So therefore the state counted with all resources and mechanisms necessary and tried to not only minimize the organizations, reaching the point of taking away the budget and threatening the director, which was included in the lawsuit. Nevertheless, the harassment was fatal. Canada tried to dilate everything. They interposed appeals. They appealed, and at the end was condemned and ratified the condemned in 2021. It wasn't very good. The sentence, sorry, in 2021. I don't know. What the main thing was not respected, right? The superior interest of the child, the right that all child must have their own childhood, and this is sacred. This lawsuit or this trial took 6 years and 9 years for a sentence, so practically the whole childhood. The third briefer was from Chile here. First, giving some context, in time of space, the sense that there's 12% of the indigenous population. Nevertheless, there's no sort of recognition of this indigenous population, but even the constitution is to recognize the word ethnics. That's it. Ethnic. Certain commitments have been adopted even though that start from 1989, but these are not complied with and has generated a conflict with coexistence, which at the same time, as consequence, is violence, murders, out of control. They're going through a permanent state of exception there where they criminalize protests and manifestations, and there's punitive persecutions. There's no intercultural focus, and it was emphasized that no response can be given without recognition of this pluralism. Also, formative actions should be taken, such as the whole, not just the judicial power or the public ministry, if not justice itself, which should be that actions of rendering accounts must be passed and allocate enough resources for the apparatus of justice and different organizations also to seek a multilateral focus and to tackle the challenges which are common. And lastly, the last briefer from Bolivia, as from Mexico, mentioned that even though they have national and international legislation, the state does not, has given any satisfactory response. And in Bolivia, in 2009, these indigenous rights are included in the constitution. Nevertheless, the state still violates the rights, especially of territory and self-determination of such. And to the degree where there has been no, oh no, they got yellow card. There has been no previous consultation, free and informed, as it's been set in different agreements, that there has been a setback in rights awarded, especially fractioning territories. Therefore, there's no representation, political representation, or adequate enough of the indigenous population. Also, environmental policies have been more flexibilized in favor of the state and business people or industries. So there were two cases mentioned: the exploitation of the extraction of ore, mercury and lithium. And the first, there is severe concentration, which is dangerous. Each can lead to a genocide. And the state, as they have the funds to resolve this, they act on their own convenience. And what they're doing is denaturalizing the indigenous population because they've made them to create cooperatives to try to subsist in a territory which is already theirs. Regarding lithium being exploited in the salt lake of Uyuni, exploitation of 8 more salt plains have been permitted to be exploited. So therefore, they're more vulnerable. The indigenous population have more vulnerabilities and exploiting the land. And lastly, there were many comments. I'd like to point out the participants from Guatemala and Costa Rica as they're operators of justice. She asked herself, what can there be so there's encounters or engagement between the indigenous populations and different mechanisms of justice? Well, we shouldn't be regarded as the enemy amongst ourselves. We have to seek ways where we can truly give a response. And I know this is not the case in all countries, nor in my country. Nevertheless, there are people within the legal system who are committed, who we do believe strongly that the defense of indigenous rights, and we do wish for more engagement between both sectors to achieve at least one minimum bit of justice, because you can always start somewhere. And our colleague from Guatemala mentioned that the need for empowerment of the indigenous population, engagement with understanding their rights, and also that they are trained. I got red card. Anyway, that's it. Thank you very much. It was very enriching, so I hope that you captured a few words that I mentioned. Thank you, Judge Maria Alicia, for your summary of all these points tackled in table number 1. Now we will have Isabel Godoy from Chile, who will summarize what has been mentioned on table 2, the access to environmental justice and the defense of the environment. Hello, good afternoon. Well, in our table number 2, there were 3 countries, 4 presenters, and 4 countries. We start with Guyana. I want to go to Guyana. You can see that there's excellent environmental practices there. The representative mentioned that they had a national consultation process with all actors that lasted 7 months, and there was space for indigenous people there. So they know about the environmental rights mainly. global struggle has been led by them on climate change. Also, they have had negotiations with the state, very fruitful negotiations for indigenous people. There are spaces which are considered reservations there, where no one can have access to that area where that is indigenous territory as a resource for their own for their existence, but they do manage the territory themselves. In 2009, that agreement was signed. Derek mentioned this. Also, he says that 10% of the population of Guyana is indigenous, and 16% or 16% of property is in the hands of the people, and the people, indigenous people, must be compensated with participation because of the use of the territory. So therefore, it's carried out there. That's why I say there's excellent practice, because it's not the reality of other countries here present. For example, in Peru, all the obstacles which exist currently are with them. They're under dictatorship, which does not allow them to have access to be able to practice justice. They're in the same struggle that we were in with the previous process of trying to recognize the rights of nature as a mechanism of protection of the environment. However, they have serious obstacles there. And the right of peoples of consultation, which is within the Agreement 169, if they do not press action throughout mobilizations on this, neither that right is given to them. They say that at the moment there should be many consultations, nevertheless only some are chosen, which are convenient for the state. And therefore they mobilize themselves in creating that or exerting that right that we indigenous people have. Our other brother from Peru in a remote area, the state does not arrive to these very remote areas, so therefore they only arrive when there's interests involved of intervening that territory for economic purposes. Peru also has a double discourse. Abroad, it adds itself to protecting the environment, but inside, domestically, they offer. It's a country which is it offers itself as for a mining company, mining country, criminalizing the indigenous peoples or anyone who opposes this development. And the internal discussion or conflict is given within the country, because on one side, indigenous people accuse us of that we are the ones who oppose to the development of the rest of the population. But the reason is that what we're trying to do here is to protect the environment for future generations, due to the context that we're going through on climate change. In the case of Bolivia, Bolivia has a plurinational constitution. It has articles included, which specific articles that protect the rights of indigenous people, consecrated the rights also of Mother Nature, and also once we read this, it seems like paradise. It's what we all would wish for. Nevertheless, when they want to exert these rights, there are laws which do not disable like the exercise of these rights. The brother said that we have our land, we have our rights, but when we want to do something, we can't, because a law pops up, and when we react through the indigenous justice, many times those who are defenders, at the end of the day, are judged. So there's no protection. So not always the rights worded regarding the reality of indigenous people are truly exerted there from these mechanisms. That's it. Thank you very much, Isabel, for your summary. Now we give the floor to this table number 3, where they talked about the mechanisms of protections of defenders within the investigation, using investigation, rendering of accounts, and access to justice in the case of murders and any affliction to the lives, integrity of defenders, indigenous defenders. For this purpose, we have our colleague Dak Lema, who's going to summarize the discussions on Table 3. Thank you very much. Well, our table was made up by Carlos Quesada, Executive Director of Equality, Salvador Valesano, Indigenous Council, Miguel Mesquita from the Inter-American Commission of Human Rights, and Sara of Central America. So on this table, we talked about different issues that we're going, and I will mention certain points considered central of discussion. Initially, we tackled the topic of the duty of the state in indigenous conflicts, where the states should prevent conflicts amongst indigenous peoples and the companies, or between them, or third-party actors, as also to avoid colonization of indigenous territories. It was exemplified the inefficiency of the mechanism of recognition in certain countries of Latin America, which generate, or the Americas, which means the persecution of defenders. Sarah Nebo said it's necessary to mitigate risks of defenders, measures of violations of human rights in the cultural causes that create these risks. So according to Miguel Mesquita, we need to identify the causes that lead to the risk. There's no protections without cause that generate a risk. If not, we have to continue with the same situation without the existence of effective mechanisms. So therefore, it's necessary to support the mechanisms of protection and investigation in context of crimes, for example, like crimes against the environment and against communities. This process must be carried out with a differential focus. States also should implement these focuses within the justice system, and we cannot work on the defense of rights if there's no differential focus. That also is connected to, as a consequence, to the causes of murders of defenders of human rights. We analyze the causes of these murders, the lack of recognition of lands, territories, as one of the elements that lead to these types of situations. Impunity of the entrepreneurs and the reduction of civic space, especially in Central America. We have worked also on defenders of human rights, collecting a definition that was given this morning, that was mentioned when it mentioned that defenders of human rights are identified as individual and collective defenders who promote and protect their human rights at a local, regional, and international level. Starting from this definition, we should also, Mr. Velasco mentioned about the case of the Indigenous Guards, where they mentioned that they have positioned the role of Indigenous Guard as peoples of trust from the same local leaderships of the local community. So therefore, it's necessary to assess this pertinence, which starts off can begin with trust. Now, access to mechanisms, this is very often they have to wait about 2 or 3 years, and these mechanisms of protection arrive late, even when people have lost their lives. For example, it was mentioned that it's not enough to give a telephone or bulletproof vest, where people may be exposed to violence, or cell phone in a context where there's no access to the network service. So there's no point, does not protect the defenders of human rights in that fact. It's not enough just a cell phone or a bulletproof vest. In the case of Colombia, the Indigenous Guard is more than just a person with a stick. No, it's the care of the territories, and they direct themselves to a recognition as defenders of life, to understand also this collective dimension of defenders of human rights. Criminalization of defenders of human rights also was mentioned, where we discussed on the current context, where defenders of human rights face threats, violent attacks, and criminalization of their tasks, including the unduly use of penal right to persecute the social manifestation. There were questions also related to safety on the digital area, or security, and it's evident that we need to work with alliances, with networks which guarantee these types of tutorships as new mechanisms for defenders of human rights. Saranueva mentioned about the actions, effective actions, those that are directed to generate spaces of exchange, and even in digital area, it's necessary to work with alliances, with networks, which effectively the main task is to guarantee these types of tutorships. Regarding investigation on murders of defenders of human rights, it was mentioned the importance of investigating these murders of defenders of human rights was mentioned, considering all the material authors and also the context in which these occurred. The companies and corruption were identified as factors related with these murders. Regarding the Inter-American system of human rights, the importance of the Inter-American system was mentioned, and the protection, and also the need of the indigenous peoples for major use of organs available for this. On this path, there's an important topic about gender and protection of defenders of human rights. We measure the risk, especially considering the exercise of defense of human rights on behalf of women, indigenous women, as there's more masculine, there's more male leaders than women, so therefore it makes us understand that we need a particular focus on this. The systems, it's mentioned also by Ms. Velasco, must recognize that within the states there are indigenous governments, and the relation with these are fundamental. To conclude my words, the lines of action for the implementation of mechanisms of protection are actions necessary were mentioned to be able to implement mechanisms of protection which are effective, including the cooperation from the system of the United Nations, mitigation of risks, and strengthening of legal frameworks. Thank you. Thank you very much for your summary. And now, very briefly, I will summarize generally all the topics mentioned here in each of the tables. Table number 2, much was mentioned about the situation that the defenders face, defenders of the environment and defenders of human rights as well, and also people from indigenous communities. Now, the concern also on the link between organized crime, armed forces or safety or security state forces, the state itself as well. Also was discussed the specific obstacles which children face and young people face, indigenous youth, regarding access to justice, as it was given in the case of Canada. Also, the lack of recognition was mentioned of indigenous populations, criminalization of manifestation or protests, and the lack of differential focus on the persecution of crime in Chile. And also, in Bolivia, it was mentioned that even though that there is an indigenous justice system, nevertheless there does not exist a satisfactory response, because they also have a violation of the rights to territories, to land and indigenous peoples due to the lack of a consultation and previous consent, free and informed. Also, this lack of consultation is very much associated to the extractive activities, specifically mercury and lithium in these indigenous communities. Now, on table 2, it was mentioned that the best practice and experience is given in Guyana regarding the national consultation process and the management of territory that indigenous peoples have. Also, it was mentioned that there are significant obstacles which do not allow the access of justice regarding the right of nature and the environment, specifically in Peru, and the lack of access to justice in remote areas, so the impossibility that the justice system can actually arrive to these areas. Also, we associated criminalization of the indigenous people, and it is mentioned that indigenous people, generally speaking, opposed to development. That's what it is said. As a consequence of this, indigenous peoples, generally speaking, what they seek is to protect the environment. But we have this idea that they are opposed to development. That's what's given. On table number 3, it was mentioned that the duty of the state was mentioned there, of preventing conflicts between indigenous peoples and third parties. It is necessary to mention mitigation of risks and investigation or with a different focus with due diligence as well for these attacks on people and defenders of human rights, indigenous peoples as well. Also, it is mentioned about the need to set effective mechanisms and fast mechanisms to investigate causes which generate these attacks and criminalizations of defenders, or this associated to an undue use of the penal right or criminal law, on the persecution of the right to social protest. Also, what were the main causes identified in regarding threats that defended people face, like recognition of environment, impunity of the business world, and weakening of the civil space. So we invite you all to mention your comments, your ideas, your opinions, or your questions. Thank you very much. I'd like to thank you. Like in the case of Colombia here, we remember there's 115 indigenous communities organized structurally in 7 national organizations. In this sense, also, we'd like to mention many issues here to the United Nations and the justice operators. I'd like to tell you that to understand, to interpret, and to resolve these issues which have to do with own governments and the administration of justice, there are 5 very important elements. First is the context. The analysis of context on the political, cultural side and economical side is very important. The second element is regulations. There are national regulations and international regulations. Nevertheless, regulations based on their own rights, own laws, natural laws, which indigenous community must have. And this should communicate with other legal systems implemented as well. The third element are the obligations of the state and governments, which not only should have a policy within a decree or regulation, if not, these should be true and effective and real at the moment of materializing that right within their policy as government. The fourth element are the guarantees. There must be guarantees, not only procedural, if not regulative and political and economic also. Because it's all nice to remember and to understand that indigenous peoples are protectors of the universe, the territory and the land and the environment, but it's very complicated when materializing and protecting these guarantees for these governments, their own governments, and their legal entities can be effective on these. And the fifth are actions. Political actions should always prevail on human rights and communication. Communication allows the visibilizations of facts and damages and harm presented itself, not only within the Latin American territories, within the rest of the world. And here, very important is visibilization throughout communication, which is own, unique, and adequate for each people or community, which allows us to understand us in real time about these situations and not to see the huge massacres which were maybe foreseen with earlier alerts, but then are unfortunate and also only left on a paper discourse and apologizes that authorities give. And maybe we could avoid. In this case, we recommend from this our own government, we have to recognize our own authorities, our own institutions that are legitimate, legal, and also our own ways of exerting territorial control in case of Cauca and Colombia, the indigenous guards in other countries, for example, in similar cases. But also, for our discourses, we also have to maintain a discourse of harmony, of reconciliation and peace. The discourse for us leads us to generate a discord due to all the afflictions in many directions where we can have. Now, the recommendation is to maintain that interdisciplinary coordinated actions, interinstitutional ones, which allow us also not to compete in the institutional offer, if not to reach an agreement on the pain, the need that each community requires. And finally, we invite the states part of the United Nations also to understand that indigenous jurisprudence is legal, is a fact, and this special jurisdiction, indigenous jurisdiction, not only takes on penal and criminal actions, but also things that that afflict the life, but also they're not regarding the ideological or religious environment and cultural access to justice, as indigenous jurisprudence collects all facts which merit without considering race, color, religion, or political, economical status. Thank you. I'm Alberto. I'm from Paraguay, the Guarani people. I was in table number 2 and I shared with our colleagues. It's something that we have to tackle. It's very important for the creation of the states to protected areas. In Paraguay, at least, we have this, but it's not just as it's mentioned. It's not just in Paraguay, but it has much to do with international organisms. As territorial rights, it's like having indigenous people versus free areas. You want to talk with indigenous populations for intangible, tangible discussion, but for indigenous people, an ancestral territory is biodiversity, not just the forest or the air. We have water, sacred areas. So therefore, at least I come from a territory which is, for Paraguay, not another country, thousands of hectares that the Paraguayan government has conceded to us. This ancestral territory is from our culture. It has a name for us, and then it has a name for the white man. So it'll be interesting to understand this. I agree yesterday with a person that came from the United States who said that when do we have access to justice in our territory? Up to which point? I mean, not just access to justice, or do we articulate actions with the governments? I mean, another terminology, or making respect our autonomy, like our brother from Colombia mentioned, to have our own authorities that the government should respect within international standards. Paraguay, within its constitution, first we have the national constitution, then we have the international treaties. This means that international treaties are at a high level, and even so, Paraguay has a huge amount of indigenous population. Thank you. Good morning, ladies and gentlemen. I'm just going to make a comment very quickly on the green funding. I recommend you to read my report that I've just presented before the Council of Human Rights. There are many things that you're mentioning there today. But also, I was participating for a few moments here on the table that was table number 1, and I would be interested also to understand, or maybe you could reflect what our sister from Canada was mentioning regarding the defenders of human rights receive sort of threats, especially those who are defending the rights of children and women. So that's what I want to know. Thank you.
Bueno, creo que esa estuvo pues muy relacionada a
This
lo
is
que
very
nos
much
pasa en la realidad a los pueblos cuando
It's
estamos
very linked to the
en los territorios, ¿no?
what happens to us within our territories,
Las amenazas
because
que
the threats
existen contra nosotros
against
las
us
violaciones a nuestros derechos
and
a la
violations of our
vida,
human rights and of
pues
life
están al día.
are up to date.
Que van desde
They go from
de las descalificaciones a nosotros y sobre todo a las mujeres, diciendo que las mujeres
misdemeaning women, because they tell us what women have to do here. We're fighting. If not, our husband beats us, or as if we don't have anything to do at home. That's what they say to us. They say, "Oh, what are you doing here?" So the government they have campaigns against us. They say that we are people who are against development. I think that is something which crosses all the slander that we suffer, we defenders of indigenous rights. They tell us these things. Now, on access to justice, environmental justice and defense of the environment, well, we as indigenous populations, we consider this as just one, not separated. Territory for us is everything. It's part of life. It's these are the trees, the lands, the water, it's the wind, it's everything that surrounds us and where we sustain our spiritual practices, religious practices, and of life and reproduction of our culture and our life as indigenous peoples. And this is what is being denied to us. We are being displaced. We are being obliged to exit our territories. So these mega projects can arrive. These ones, in the case of Mexico, for example, we're talking about many, but what they want is not just territorial reconfiguration in the southern east part of Mexico. If they want to reach Central America, to occupy Central America, because it's the continuity of the gas pipeline that they want to create a pipeline from Chiapas, Mexico, and crosses Guatemala. And that's what they're trying to do. Also,
the trains also go to Guatemala in order to use all the corridors that are trying to do this with the governments. The cooperative interests, international interests, the interest they have on our territories. So we're not just talking about a country, we're actually talking about an occupation, territorial occupational strategy on behalf of what we're seeing right now is the States, United States, in competition for these territories with the Chinese economy. So it's not something that is easy. It's not something that can be done. For instance, in Mexico or our area from Huantepec or the Maya area where they are promoting 2 trains. And in the topic of protection mechanisms, and for instance, yes, Guyana, the colleagues from Guyana, it's so nice for them to respect, because in Mexico, when they declare protected areas, we fight to declare protected areas, because protected areas are there where we as indigenous people, we cannot go in order to do the management we do permanently for the protection of these territories where we live. The protected area, if declared protected area, it is the entrance of the government to provide it to the companies, so they take us from us to deliver it to the company. It is the first step for the delivery of our territory as protected areas with companies. In the topic of the mechanisms for protection, I don't know. It's not very useful to us. They killed a colleague, Ricardo Lagunas, disappeared since January, a lawyer, and he disappeared, and he had the protection of this mechanism, protection for journalists and advocates. It doesn't guarantee anything, and they are the same perpetrators that needs to respond to the whatever aid, whatever help we ask. If not, what they do is to lock us in our homes with thousands of lockpads so we don't leave, which is not what we want. What we want is to be free in the territories, doing our work, doing our jobs. Another thing, I am not an indigenous advocate because one day I got up and said, I'm going to be an advocate. It's not something like that. It's because the conditions and the situation of what was happening in my community took us to be in this space. And when we realized we were there with threats and being disqualified and building a movement to defend the territory. The colleague from Guatemala, thank you so much. I think it's important to think about the exchange of experiences of our people. It might take us to strengthening. Through these mega projects, we've been told that development will be here, but it's also important, and we've done it. It's important to have our own agendas, just like we see development. We have an agenda which is quite general, of women's, of young people, and an environmental agenda to be ready to implement them. So maybe we can do that right that we have for our free determination, how we visualize the development for our communities. Thank you. So Luis Jimenez, Aymara people. I wanted to speak a little bit about the national strategy of lithium that is being currently developed by the government. Even though the Ministry of Mining has pointed out that this industry must be done with the participation of the indigenous people, the truth is that we have been missing for this dialogue or speech beyond good faith. It's approached from this right to consultation process, but leaves aside the recognition of the right of free determination of the people. They don't really speak about the fact that the people have the right to define their own development priorities, the right to territory, lands, and natural resources, and so on, especially in a context and a regulatory context in which, at least in the north of area where I come from, there's no collective titles of the territories. There's a terrible scarcity, hydro-scarcity, or studies for the impacts on climate crisis, and something that differentiates the indigenous people from the south when thinking about the ones in the north. This permanent situation of extreme poverty and abandonment from the state in this territory, that it means a very difficult situation, because the businesses start buying the leaders, and they divide the communities, and the communities, because they don't have work opportunities with the situation of vulnerability, economic vulnerability, they end up being forced to negotiate directly, dividing the communities itself. Even in territories where it has been declared, they say, areas under official protection, they still have concessions. In my territory, for instance, the mining concessions, despite that they have a national park. I want to take the opportunity that we have the people from the special, the new process. We have the advisors in Chile. We have a new constituent process. Even though it's been recognized as the Constitution is the supreme norm, and international treaties such as the National Convention from ILO, there's a specific norm in the new proposal that inhibits the judges and the authorities to apply the Declaration of the United Nations, to apply the American Declaration. It is in the proposal, the current proposal in the draft. And this should be a warning. Human rights of indigenous people are not only in convention 169 in this agreement, but international tools that we are commemorating. But the current process wishes to inhibit that application. That I just wanted to mention that. Thank you. Thank you to everybody for your ideas, your comments, and if you have no comments, we will continue directly. Sorry. Very fast. We give the microphone because we need to continue with the agenda. Yeah, it's been a questioning because we agree in all the threats, in all criminalization, in the eviction of the land and the territory, and the celebration of the 75 years of the Declaration of Human Rights. I question myself and I think, okay, what are we going to obtain from this? What is going to be the agreement or the commitment of everybody? Because we see that indigenous people don't have the backup from the government or the authorities, the judges, the magistrates. We do not have that backup. But it seems like everything that has happened, the murders, the kidnappings, the disappearance. So what will happen? A while ago on the table, I was saying, okay, what are we going to do? What are we going to do? All over the world, in our country, how are we going to solidarize ourselves? As we say in Mexico, and the Zapatist colleague says, if they touch one, they touch us all, because the territory is from everybody. And when dealing with these problems and this disappearance that they want to do with the indigenous people, what do we need to do now? So we're going to have dialogue, forum, and the meeting, and so we finish. Strengthen with force, but what is this articulation going to be on the countries of the people? Thank you so much. The answer is going to be on the next phase of the session, which is the idea that we have been establishing, we have been promoting this dialogue. So we will continue now with the announcements from Marceline. Thank you. So I invite you to take a seat. According to the agenda right now, we close the live broadcasting and we communicate that during the session from yesterday afternoon and part of the evening, we've had some brothers from some countries, and now we're going to ask for us to do a new picture with the same circumstances from yesterday next to the dining room, and then we're going to have lunch. Then, please, to finish with the question that the sister asked, we will return to this table at 2 p.m. with the closing dialogues, but also the commitments. And we will read the conclusions of this event. Thank you so much. So for the colleagues of communication, they will send you everything for the picture. 4 of the forum. And so for this, we will invite, first of all, Bettina Cruz. So if she can please join us in the podium, Miriana Jumbay, expert in legal jurisdictional pluralism from Ecuador. Francisco Cali, our rapporteur for the rights of indigenous people from the United Nations. Mr. Rapporteur, if you can join us, please. We take the opportunity to present our regards to those who are following us in the YouTube broadcasting. This is a closing dialogue that consists mainly in analyzing the role of the protection systems for human rights and access to justice for indigenous people. These are comments, synthesis, a briefing of what we have been doing in yesterday's and today's session. I'm going to give the microphone to Javier Mena, regional representative attached from the Office of South America for the High Commission of the United Nations. Please go ahead, Javier. Thank you so much. Now this is the closing. It is a session that I know will continue to be extremely important due to all the interventions we have heard along these days, but not only these interventions, but also the bilateral conversations, lunch, coffee, even outside the hotel. I think that they are as important as the keynote lectures that we have heard. And so we will start with the closing dialogue. We have about 1 hour. We will listen to the speakers that are joining us with the role of the systems for the protection of human rights and access to justice for indigenous people. We have about 10 minutes per intervention, and in the end we will finish with a brief dialogue so we can wrap up this part of the dialogue in order to go to the conclusions. And so we will start with this closing dialogue with Francisco. Go ahead, Francisco, we have 10 minutes. Well, thank you so much, Javier. As you said, this event that wraps up today's session, it's been an event with great opportunities. Has made possible the formation of networks, connections, relationships in order to exchange experiences. And you know, that is the idea of the international and regional system for human rights that plays a key role to guarantee the right of indigenous people due to several reasons. First of all, because the international system offers a moment of legal resources, or quasi-legal, almost legal, when dealing with injustices or lack of injustices in the internal environment. Secondly, the international system has offered indigenous people a space to participate that allows them to promote the adoption of new protection instruments for the rights of indigenous people, such as the drafting of the UN Declaration on the Rights of Indigenous People, the creation of new spaces where to execute them, such as the creation of the rapporteuring on the rights of indigenous people that I will be mentioning in a moment. From the participation of indigenous people, and I say this because yesterday, as it was mentioned, what we have today, so far, I mean, has not been a gift from the governments, but better yet, very, very hard work of lobbying, where the work wouldn't end at 6 p.m., as many officers from the United Nations do and end up working, and didn't start at 10 or 9 a.m. Our work many times started from 7, 8 a.m. till 2, 3 a.m. but next day, right? So I know Hector Huertas, one of the lawyers. We had the opportunity to work together in many negotiations with these instruments, with these tools. So what we have today has been the result of those efforts that were carried out. It's not a gift from the government. It was not an automatic thing. Even the declaration in the discussion, it didn't start at the work group, but the celebration of the international conference of the NGOs that were supporting the fight of indigenous people in Geneva in 1977. I do think that there's a lot of history that we need to rewrite. So many people don't say that has been the results of their work or the result of the work coming from the States. And I say this in the sense that it's enough to think about the jurisprudence developed by the Inter-American Court for Human Rights on the participation of indigenous people, the previous free and informed consentment and the right to collective property. The minister, and I tell her minister, because when you're a minister, you never stop being a minister. Minister Orriola was saying today, the cases we see the most in the Inter-American Court and the Commission are related to the violation of the fundamental rights to previous free and informed consultation process, the land, the territories, the abuse coming from the international businesses, the companies, mining companies, that are developing mega projects in the lands and territories that are from indigenous people. To that, we need to add the key role played by the organisms on treaties of the UN and the Committee for Racial Discrimination, the Committee for all forms of discrimination against women, the Committee for Human Rights, and the Committee for Social, Cultural, Economical Affairs that have adapted the interpretation of human rights embedded in their different treaties to the specificity of indigenous people through decisions and general observations. Let me tell you that the Committee for Racial Discrimination, before adopting the declaration, the American declaration, and also the one coming from the UN back in 1997, the Committee for Racial Discrimination Elimination had adopted the General Recommendation number 23 that speaks essentially about the right of indigenous people to previous free and informed consultation process and the right of indigenous people to land and territories. I do think there's a long way that has been traveled thanks to the advocates of human rights. Due to this premise, I limit my analysis to the rapporteuring on the rights of indigenous people that I'm entitled right now, with access to justice on behalf of indigenous people. Why do I say this? Because one of the ideas of this rapporteuring is to provide a mechanism to surveil, guarantee the respect of individual and collective rights of indigenous people, established in different international instruments, specifically the Declaration of the United Nations on the Rights of Indigenous People. This is a declaration, the product of years of lobbying, hard work on behalf of the indigenous people around the world, and not just here in this continent. In the basis of the UN to get an instrument that recognizes the legal special status of indigenous people. And so far, the declaration adopted back in 2007 by the General Assembly of the UN, which is the norm, minimum norm of international protection of the rights of indigenous people. And as Antonia said this morning, I underline this, minimum rights, because the states thinks it's the roof, and the United Nations has clarified this. It is the basis where it should start, the starting point, the respect of indigenous people. It is the basis, it is the first step we can call it. One of the main functions of this repertorying is to receive complaints, claims on violations of human rights. This is information received on behalf of indigenous people, the indigenous organizations, the civil society. So the information received is analyzed, and if it's deemed appropriate and possible, the rapporteur, together with other special rapporteurs, can send a communication to the state indicating the alleged violations to human rights, questioning about the measurements that are being taken in order to deal with the situation. Since the beginning this year, together with the other rapporteurs, I have sent 120 reports to over 28 states and other entities such as private companies and organizations, intergovernmental organizations. Can you imagine 128 communications? Each report, each communication is required to requires research, investigation, but also to prove what's being complained about. Because it's not only because Javier Sensa is my friend sent me a communication, automatically speaking, I'm going to take it, I'm going to communicate with the state. I have to do research. I need to investigate what's actually happening to send a communication with basis. Unfortunately, the team we have is very small, but fortunately, very capable, very professional, answering, responding to the needs of the indigenous people. Not fully. We have a pending amount that we need to communicate, but we're unable because of the lack of personal financing on behalf of the state to the United Nations. Since the beginnings this year, together with other among the first violations complaint, the execution of projects for development on the ancestral territories of indigenous people without consultation or consent, and the harassment and criminalization of the indigenous advocates. These communications to the states are an important tool used by indigenous people in order to complain about the violations to their rights. In some cases, sending this communication gives place to an immediate response on behalf of the states that ended the violations or started a consultative dialogue to overcome the problem. The communications that are public after 60 days can be used for indigenous people as part of a legal strategy to defend their rights. In special severe cases, the issuing of communication is together with a press communication on behalf of the UN that can call the attention on the audience on the situation of the rights of indigenous people of a specific community and to generate pressure on the state to cease the violation of it. The communications can also be sent to entities of the private sector. In the case of the communications to companies, in some cases, can be the only means so indigenous people can complain with the private company that is violating human rights. This happens if the company has not established a mechanism of complaint, appropriate complaint mechanism, or there's inertia in the justice state system when dealing with violence. The communication can be quite efficient because it can be a way of negative advertisement for the company that can push them to take some measurements. Another key activity of this mandate is to make a declaration of the official visits to countries in the year. This is a very important activity because it allows the indigenous people from that country to complain about concrete violations of human rights that after being analyzed and based, they are part of a report where concrete recommendations are performed to the state to move forward in the application of human rights of indigenous people from that country. For the Q&A session, I'll be able to talk a little bit more about what I have written. Thank you very much. Thank you so much, Francisco. In the end, we will have a short briefing, a summary. Now we're going to listen to Bettina, advocate from Oaxaca. We'll speak about the Women's Network. Thank you. You have to go and do it hard, right? Because I was doing it gently. Good afternoon to all of you, men, women, and everything in between. I was invited to talk and comment on everything that has been discussed today from my own perspective, my own struggle, what we're doing in the territories. And indeed, as the rapporteur says, yes, there are frameworks and protocols that must be complied with, that are not free concessions coming from the governments or the companies. They have been conquers of allies that the people, the nations have had in different spaces, in this space, in order to build these frameworks and protocols for access to justice of indigenous people. However, many times those protocols, those frameworks, it's not possible to land them, to communicate them in the territories because the conditions don't exist, or maybe the governments do not have the interest of improving the conditions, life conditions, and access to justice for indigenous people. And that is because there's another framework, another more important framework, which is the context, the economical context that we live. We live in a capitalist, cooperative type of system that mandates that the businesses, the companies, well, they want us to go to one type of development, a Western type of development that has been imposed to us, where our life as indigenous people is not worthwhile. It is undervalued. They made us look as if we were inferior beings that know nothing, beings that they need to come here and civilize us. And the fact is that we belong to very large, sophisticated, ancient civilizations that are still alive. In the case of America, this was the colonization. The colonization left us in this state. So there's a historical debt with indigenous people. And so this access to justice, it's a bit complicated to get to it. Because as I said, we are in this system, so the government sometimes don't listen to the government itself, or the population, or the community, or the citizenship, if you can call it as such. But better yet, the guidelines mandated by the large corporations. So now they need more acceleration for the transportation of goods. Okay, let's have an interoceanic corridor in my land, in my oceans. Let's have a high-speed train that goes through 300 kilometers, and let's put a highway there. It doesn't matter if we remove all the territories to ruin the hills, if we ruin the ecosystem, it doesn't matter. Let's have 12 industrial parks. We need water. We're going to pollute it. We're going to contaminate. We're going to use cheap labor. We're going to do awful, atrocious thing to population without even thinking about us. And that's the thing. The previous free informed consultation process, that is not happening. And if it's done, if it's for the government's benefit, and then they justify this imposition of these mega projects in our territories. And that is what we go through with that mega project, with the mega project from the Maya train. Several mega projects that are reconfiguring the southeast of Mexico. Not only the southeast in Mexico, but Central America. And I've said this: Guatemala, Honduras, Panama, Salvador, Nicaragua. It is the empowering, the geopolitical control of these territories, the one that the U.S. government requires, and it's competing with the government from China to take control of this territory. That means more acceleration for goods, and it means more consumers and more natural goods that they wish to have, because this area, by random, is an area of a huge biodiversity, cultural biodiversity and natural biodiversity. And it's an area where we have forests, water, so much water, jungles, and many originary people live here. We are taking care of those territories. So the consultation, the governments don't do it, or they do it. Well, as in Mexico, consultation. There was an assembly with people like 5,000 followers, And he said, "You want the interocean corridor?" And people was like, "Yeah, okay, the people has decided that, yeah, the corridor is there." The consultation is this. This is a process, the consultation process with procedures that will try to communicate to the agreement of the people. But there's another thing. This consultation, someone said it a while ago. The consultation is some type of as if it was a free determination of the people. The governments wish, with the type of consultation, they wish to have this type of agreement different to what the people really want for their lives, for us to execute and live in autonomy. So that is not, I mean, the consultation process is one thing, and free determination is something completely different. It is for the people to be able to decide how to live and how to enjoy that life, execute that life in an autonomous way. That's, well, then when the people say no, no, we don't want these projects. We do not want this type of consultation process. We demand. We have protection tools. We will communicate. We will disseminate. We will go to the UN. We will go to the Inter-American Commission of Human Rights. We will mobilize ourselves. We will perform direct actions in our territory. If so, what happens? We are criminalized. We disappear. They kill us. We go to jail. They moves us from our territories, and that's what happens. So where is that framework? At the beginning of this works, I was asking, who forces the states to comply with the regulatory framework? Who sanctions them? Who surveils them? Who's there for that access to justice of indigenous people can really be fulfilled according to these frameworks and according to these protocols and according to these conventions? This is a meeting that I have liked so much because regardless of the fact that I want the UN, that we have the UN, we've had much space for us to speak with the indigenous people, much room to say our word, to talk about our words, to speak about what we feel about. And how we feel is this. Even though we have protocols, frameworks, requirements that we need to follow to impose these projects in our territories, they continue to impose themselves because nothing stops the company. And even worse, now the companies allied to narco traffic, allied to governments, we have narco governments, and the companies are almost invincible. However, we, as defenders of indigenous people, of the environment, of the territory, social fighters, as we said it before, social activists, we have no other way of being. We are from that territory. We have no other option than continue to struggle, to fight with all the dangers associated. What we ask is listen to us. Listen to the people when speaking, when the people send documents and asking for help, asking to do and some investigation, some research. And as the rapporteur said, that they're not going to say more because we ask them to investigate. And that is what we want. We want them to investigate or to send someone in those territories, because I believe that they need to go. They think they need a government's invitation, and sometimes the governments don't want to invite them because of that. Because but if you can do investigation, if you can send any letters, if you can do that type of actions, we're there always, and we're fighting. We are defending not only our lives, but the life and the likelihood of life in this planet. Because whatever happens in indigenous territories right now, which are the ones that preserve 80% of biodiversity of the world, if you evict us from that biodiversity, what will happen to this planet? This planet won't have any possibility. Maybe the company, the powerful people, they have a plan B and a planet B where they're gonna go and live. But what about we? We're gonna be left here. So thank you so much. I really appreciate the opportunity of being able to to speak in this space. Thank you so much. Thank you, Bettina. We will go to the third intervention with Mariana Yumbay, indigenous lawyer from Ecuador. 10 minutes, please. Thank you. Good afternoon, everyone. I think that these have been very rich sessions, these very fruitful days, and together with others, we said that the time maybe has been an enemy. We would love to share all the situations, all the problems we're going through in each one of the countries, but it's been, well, time has been an enemy. Regardless of this, I believe it is key to consider the role of all the protection roles for the protection of human rights has been key in the different processes that have been carried out for the recognitions of the rights of indigenous people and also the defense of them. They have also played a very important role to visibilize the vulneration of the rights of the people. In the same way, they have contributed to incorporate that vision, that philosophy of the people in the different decision-making, and also the action of incidents that has allowed to put on the table, the debate tables on the different scenarios. From the different interventions performed by the brothers and sisters representing indigenous people and others, we have verified that indeed the right to access to jurisdiction on behalf of indigenous people has been recognized in the different instruments, in this case the constitutions of the Republic of the region. In some countries, they have developed constitutional rights and constitution secondary norms. In some others, we've heard the sentences dictated by the hard courts. Now, speaking about the Constitutional Court, despite all of these efforts, what we observe is that there is still a huge gap between what has been foreseen in the norms, in the international tools, in the sentences, and what happens in practice, right? So this has been seen from the persistency of the several problems that still affect the indigenous people, such as the existence of cases of criminalization. And it is not criminalization because of any action, but for executing the right, because of the execution of right. And this is something that happens with all of the brother countries, all the peoples, all the nations, all the advocates of the land and the environment, among others. We also see data of murdering of our brothers and sisters, and also cases of, unfortunately, still happens, the subordination. When speaking about legal system, the ordinary system to the indigenous justice system, that's simply without the okay of those who do ordinary justice are not of no use. We also see the evidence of the persistency of actions of discrimination and racism that continues to be structural racism. Even in plurinational states and intercultural states, as in this case in Bolivia and Ecuador, the people and indigenous nationalities execute the indigenous jurisdiction that solve conflicts, and in such way, I would say, would contribute to guarantee peace and harmony in their territory, and should be considered as a great support for the state. However, does not receive any recognition. Completely the opposite. For the execution of this right, they go to trial. The author, Antonia, said, in the case of Ecuador, for the defense of the rights, they were incarcerated, condemned to 10 or more years of incarceration. And what did we have to do? To go to the National Assembly, to a different function, to execute the right to amnesty. Can you imagine another fight? And why? Because of the execution of constitutional rights. Also because of the defense of their lands and territories, for demanding better conditions, life conditions, in a framework of respect, to live with dignity. Dignity that implies what? Living in their habitat with water and nature, or whatever we call our motherland or Alpa Mama, is not mistreated, where they guarantee the full execution of the true autonomy and free determination, where the real dialogue, intercultural dialogue happens, where you can actually have pluralism, legal pluralism that is equal, not that subordinated pluralism like the one we're going through right now. Likewise, we see the evidence that from the states, actions are not being carried out in order to strengthen this exercise of the rights on behalf of indigenous people. Therefore, I consider that it is still require perhaps more work of all the organisms of the protection systems for the protection of human rights, with more incidence on a level of a state or permanent, to implement mechanisms that will allow to assure the execution, the exercise, and the respect for rights to access of jurisdiction in the people. It is required to promote actions of follow-up, continuous follow-up, in order to assess the state, how they are complying with the rights embedded in the different instruments. So what are the public policies that they are adopting? What are the secondary norms? What are the economical resources, or how many economical resources have been assigned for the implementation and full execution of collective rights, for instance? Or what other actions are being performed? In the opposite case, nothing happens. I also think it's key to generate more encounter spaces between the organisms and the state, from the state, but with the real decision makers, with the authorities of indigenous people and the organisms of the human rights protection system, that will allow them in this space to identify and analyze the different problems that affect the implementation of this right, such as access to justice, from establishing concrete actions that will allow to solve such problems, and for them to be a continuous object of follow-up and assessment. It is also required to raise continuous reports of countries to see the evidences of the problems. For instance, in the permanent forum next year, it should be a topic, this very key topic of access to justice on behalf of indigenous people. We also consider that a regional fight must be promoted. As we've seen yesterday and today, the problems are similar. So why can't we have a regional joint fight? Because the problems are similar in all of our countries. That would contribute to prove that it's not a problem from Ecuador or Peru or Colombia or a specific nation or people, but the violation happens in all countries against many indigenous people. We also consider that the organisms from the protection system for human rights should join the defense process, defense to access of indigenous jurisdiction and the completion of rights, to perform continuous visits on site, on the fields, an action that must be useful as a pressure measurement for the strict respect of the rights of indigenous people, and also for the implementation of them. And these visits should be coordinated with the authorities from the organizational structure that represents each one of the countries. Last year, in the dialogue process that was established with the representative from the executive power in the Equatorian state, the visit of our rapporteur. But what happened? From the state, the invitation was not communicated, but better yet, from the organizations. So how do we push so the states can be the one that invites? And that is obviously, that will provide more legitimacy and responsibility to the states. We consider that in all of these spaces, we should also promote an active involvement of the academia. The academia, still, I think it's necessary to evaluate what is the role they play, how they are training, educating the new professionals in the different areas, maybe with much consciousness, much more aware, perhaps more friendly with the rights of the people. But what are, it's being done? In the field of law, we always say, how can we have problems and strong problems with the ordinary system if we have been recognizing these rights for 14 years and we continue to have lawyers with a mindset that is basically colonizer type of mindset? And what is the role that the academia plays in that framework? I think that we need strengthening of their participation to carry out process for training and education with the authorities of indigenous people, officers that make decisions with the state that will allow the consciousness and to understand the people. We've seen in the dialogue table with the Equatorian case, we spoke about the rights of indigenous people and the new character of the plurinational intercultural state. And the officers, nothing. They just don't get. They don't understand. They still have the constitution from the 60s or 70s. This is a reality we go through. So we do need to dive in this process of training and education. Also, we have been collecting the good practices. We see evidences. Yes, there are good practices, but those good practices, we need to communicate them, to disseminate them, to set them as a reference point for the states so they can say, okay, in this country we have these good practices, and from there we can have an incidence with the rest of the countries. I also believe it's key to raise reports on the role that the communication media plays in the struggle of the execution of the rights of indigenous people. This comes from the fact that the media, most of them, the main ones, the large ones that promote the permanence of racism and discrimination towards indigenous people, to the ones fighting in the defense of the lands and territories. They have disconfigured their actions on the names that they are sabotaging type of people, that they only wish the privileges among others, other the names. So that is a reality that has to be changed by collecting reports to see the evidence of what is the role that the media plays in our countries. It is also necessary to promote an articulated work among all organisms that are part of the human rights protection system. This is with the idea of not having the duplication of efforts, but better yet, a joint effort, and for the decisions and actions promoted can have more effectiveness, given that the situation of indigenous people in the region cannot continue to be just numbers on murders for defending their rights, cases of criminalization, poverty indexes, and exclusion, because this is a reality that we need to change completely. And for that, we need to work together between indigenous people and everybody. And the other thing, finally, to help from these scenarios, from all organisms of the system for the protection of human rights and the rest key players, to the transformation of our states, to leave that colonial state, to leave those areas and to take a leap to a plurinational intercultural state in practice. Thank you so much, and I'm terribly sorry because I think I extended my time. No worries. Thank you. And finally, we will listen to a video from Anexa Alfred, member of the Express Mechanism of Indigenous People. If you can play it, please, the video. Good morning, everyone. Marugasu, all my brothers and sisters. It is an honor to be able to be in the space and to share with you some issues related to the protection system of human rights and access to justice for indigenous people. Starting by the fact that access to justice does require the possibility to require and obtain resources because of what was suffered, and with justice according to the norms of human rights. Such access is key for the protection and promotion of all human rights. In that sense, the United Nations has committed to adopt all necessary measurements for all people can access to justice. Access to justice has a very high importance because of the severity of the problems that the indigenous people are facing in the world, including discrimination in the system of state justice, specifically the one for women and young people. The topic speaks about issues regarding process equity and sustainable justice. That means fair, impartial, equal resources due to the vulneration of the human rights. Access to justice cannot be examined on a way that is differentiated to human rights, such as structural discrimination, poverty, lack of access to health, education, and the fact that it is not recognized the rights to culture, land, territory, natural resources, and the right to free determination. According to the right of free determination, indigenous people must have access to justice on an internal level from the state and externally through the constitutionary and traditional indigenous systems. They must have access to justice individually and also collectively. Access to justice must be related with overcoming injustices and historical discrimination that the indigenous people have been an object for a long time, among other things, because of colonization and to have been evicted from their land, territories, and natural resources. Associated to historical injustices, they continue to be seen currently, therefore, must be taken into account. Many of the difficulties that today the indigenous people are facing, those are related with the origin on the violations from the past. Now, the main starting point for any exam of individual collective rights, including the right and access to justice, must be the Declaration from the United Nations on the Rights of Indigenous People. The declaration is a tool, and the objective is to have justice, and it is a functional framework to make effective the rights of indigenous people. The application can be supportive in order to achieve access to indigenous people to justice. The different powers coming, the provisions including in the declaration, which are the right to effective mechanisms for prevention and repair in the case of individual and collective rights. The provisions coming from the declaration must guide the interpretation of the international treaties for human rights connected to access of indigenous people to justice. Among the access elements to justice, we have the right to an effective resource, equality in the procedure, and the need for the states to adopt positive measurements in order to allow such access. If there's a lack of those elements of access to justice, in such case, human rights protection system must be used with a subsidiary character. The role of the protection system for human rights and access to justice of indigenous people must be subsidiary. The states have the responsibility, international responsibility of guarantee individual rights and collective rights of indigenous people. About that, the United Nations, with the treaties of human rights and special procedures, and also regional mechanisms, have set on the table the need to recognize in the legal national orders the justice mechanisms of indigenous people in the region, the Inter-American System for Human Rights, for the Inter-American Commission of Human Rights, and the Inter-American Court for Human Rights. In the last 23 years, they've developed a series of jurisprudences of individual and collective rights of indigenous people, continues to be a not mandatory reference, which is key in the infrastructure of indigenous people in the Americas, different to other regions in the world that do not have this mechanism. It is a mechanism of access on the rights of indigenous people that encourages indigenous people and the states. So when they proceed, they must consider these measurements as an option, together with the principle of the international jurisprudence. It is of extreme importance that from the regionals, they can promote joint programs that try to protect the rights of indigenous people for the promotion, protection, and defense, or recognition of their rights through the legal path. I would like to finish mentioning that the express mechanism on the rights of indigenous people as a subsidiary organism of the Council of the Human Rights provides advisement and technical assistance that is specialized to states and indigenous people. As a consequence, to achieve the Declaration of the United Nations on the Rights of Indigenous People. The mechanism has the mandate of the country commitment through which we can provide assistance to states and indigenous people with access to justice in an effective way, starting from the specificity of each indigenous people. Thank you so much. We've heard 4 very interesting interventions, and I have taken notes on that. However, thinking that we don't have much time, we have like 18 minutes until the new activity. So I don't want to make a summary, but because I think it's quite clear, I would like to have the possibility of that during this time, and for the people that wishes to make an opinion on what we've heard can do so in interventions that are short, so most of the people can speak about their opinion in the topics related to the roles of the protection of human rights and access to justice for the indigenous people. So we have 15 minutes approximately. So please have short interventions so most people can intervene. We're going to start over there. Very kind, thank you.
Good afternoon. Well, first of all, I'd like to thank Francisco and our colleagues here. I think it was very clear, their presentations. No questions, nevertheless, just to tell you. Well, I very quickly had to negotiate the American Declaration on the struggle of indigenous peoples. It was passed in 2016 in Santo Domingo. So recently in Guatemala, in fact, there, 3 months ago, and now in the Assembly of Washington, the Organization of American States passed, the OAS approved a working group between the indigenous groups and the state to implement OAS, this new instrument, which adds itself to the protection of human rights, made up by 8 indigenous organizations and 8 representatives of the state. As a mandate, there's a resolution already on mandate to verify in each of the states of the Americas an instrument, a regional instrument, to regard the situation of human rights, and let us hope that next year it can give its fruits. As Francisco said, it's been a struggle of many of us here and many colleagues who are not here in Pachamama or the Mother Earth. Thank you very much. Good afternoon, ladies and gentlemen. I'd like to thank you and congratulate the panel. And what I would request, nevertheless, that in the conclusion part, it would be important that with the seal of the United States, so we can submit it to all American states, you can actually precise there that there already is a international framework of human rights which obliges all states to, as the American Declaration mentions, to recognize and respect the legal systems of indigenous peoples in all matters regarding any individual who enters their territory, and that human rights are a framework of reaction which do require coordination, interpretation, which is intercultural, and participation, and then and you cannot use human rights as a pretext for colonization, and that the interculturality is a way of interaction in the framework of a legal pluralism which is fair and decolonizing and equal to all. Thank you. Thank you very much. Well, from my experience in Bolivia as an indigenous person and our magistrates of the Constitutional Assembly, at least for me, it's clear all these fun issues of pluralism and intercultural sense, but nevertheless, this has to. The main issue are the interpretation of human rights. They have a moral value, which is important, which promotes, but there's a lack. The structure is empty, and the content of fundamental rights. So my proposal is two things concretely. That the mechanisms for the scope of indigenous people, for the reach of the indigenous peoples, should be attained. Very different though for the practice and the application of these. Now for the practice from international instances, we can develop together with the organizations of the states and the states themselves a dogma of indigenous peoples of the Americas. They're also talking about the role of the academy, and it's fundamental to have reflections on this, as in many cases the methodologies of the investigations are invasive and active within the same indigenous territories. That's another another thing for reflection, even when we go see into details and implications of international treaties, for example, on previous and free consent. But apart from this information remains available for other spaces due to barriers of different types, whether it be for access to information until elements related to linguistic rights. I believe that the organizations, international organizations themselves, must seek spaces for dissemination of linguistic rights. That they talk to us in Aymara, Quechua, different languages who are more familiar and which can allow us to understand and to have a joint process together for the promotion of human rights at a universal level. Regarding the methodology, we have carried out investigation and research, and quantitative and qualitative data have had an important increase once methodologies are applied, which are pertinent and engaged with the needs of the community. We're talking about access to justice, which has to be tackled with these methodologies, but also focused in priority groups. At a regional level, or local level, we have seen that access to justice is less for certain categories, especially women, indigenous women. So how the national justice system therefore can guarantee and start to formulate data? We need data. We lack of information, which can give us a real guideline for access to justice and also promotion of rights. Thank you. Good afternoon. I would say that a proposal here, due to the fact that our special reporter needs a lot of support as well, but we must also have duties. And I propose also the case of young people to train ourselves, to educate ourselves, to create schools of human rights, or a group of us dedicated to young people to handle this issue of right to territory, right to land, human rights, and that together with the academic world, we can prepare all ourselves. It's very important that we share tools and knowledge, and therefore support our High Commission and the rapporteur regarding the reality of our territories. I think that would be very nice in this path, to keep these things in mind, to deliver tools to the young people, to the youth, and access to justice on these matters, and we contribute at the same time with their work. Thank you. Well, I believe, before the situation which is happening in the southeastern part of Mexico, which somehow we're only articulating ourselves at a national and that region, the southern region, and therefore we have pronounced ourselves in before the organizations or the indigenous authorities, and we have carried out all the complaints before these mega projects in our territories. And the government, well, reads everything, documents, and then they say that we're pseudo-environmentalists, and they call us different names. So what I'm trying to say is that if we request for you to visit us from the United Nations, from the Inter-American Commission of Human Rights as well, so you can actually witness these mega projects, all the impacts that these are causing, and the impacts that will happen, just to make some noise in a sense, because afterwards you can carry out your declarations, your reports. But what our colleague Bettina was saying, we know that we're not calling attention, maybe yes, maybe no, but we want our voices to be heard, or the Inter-American Commission and the voices of the United Nations. We complained before the CDNH, and they didn't say anything. They don't know, nothing happens from then on. So it's a concrete proposition there. And we know beforehand that the government has to invite you, we know that, but I don't know how it's going to happen, so you can go and visit and actually witness what is truly happening there. Yes, note taken on all these. Good afternoon. First of all, I'd like to congratulate the panel, and also I've heard our rapporteur many times has mentioned this initiative. Once they receive accusation or urgent action, he immediately socializes with his other peers. So there's a better reaction regarding the state or whatever has the accusation. It's a good initiative. Nevertheless, as it was mentioned also, how to engage ourselves to these mechanisms, or how they can engage with the indigenous communities. There are many elements, instruments. Nevertheless, we feel distant. How can these mechanisms become a reality and they're actually operational within communities? On the other hand, we recognize that the American Declaration on the Rights of Indigenous Peoples is from a multicultural state. So if in the United Nations multicultural states are not recognized, or plurinational communities are not recognized, this means we're questioning their capitalistic or monopolistic sort of the right-winged, those who have had these racism and control within territories. And very quickly, whether in the criterias, jurisprudence and standards, they're saying that indigenous peoples are subject of international right. Could that category supply this obligation that only you can only visit certain areas if the state invites them? So these are the international mechanisms that I'm talking about. If indigenous peoples are subject to international law, they directly, hopefully these organisms can also visit or witness this, but it has to do with much more errands and political will, I believe. Any more questions? Because we have space for one more question. If not, we will end with this intervention. The intervention, so please to consider the legal powers as entities. Even though they're part of the state, there is a principle of separation of powers, which, let's not mistake, the state with the government. So therefore, in that sense, let's hope we engage the High Commissioner Officer of the United Nations and the legal powers of countries of Latin America, because it's necessary to strengthen their capabilities, their competences and skills. Nevertheless, that we are illustrated, for example, how we should render accounts with a vision of human rights, because we do this, but we don't do this possibly in a correct manner, or including all the peoples involved in first hand. Second place, to keep in mind projects where a consultation has to be carried out to the indigenous peoples for a real consultation in good faith, previous and informed, etc., as Agreement 169 mentions, and mentioned by the Inter-American Court of Human Rights. So it can be an engagement, truly, in that sense. So don't have the wrong idea that legal powers are the enemy. No, on the contrary. Judges, prosecutors, we are defenders of human rights. Please don't be confused. If there are no more questions, I don't know if there are any last reflections. Many reflections, of course. I believe that in Costa Rica, judges are friends of indigenous peoples. No more comment on that, that's it. Maybe in Costa Rica. So, dear Korup, I'd like to have 10, 100 clones to do what you're mentioning. Nevertheless, with the little resources that I have personally been carrying out training programs for indigenous peoples that would be the organizations who have the obligation to do this. So I've taken that role. Nevertheless, I've been in Guatemala, and I've been carrying this out many times since I was pronounced. I've also been carrying out or accepting visits, hosting visits from indigenous peoples, but there's no economic resources to cover all indigenous peoples. I'm a rapporteur of not this continent, I'm a rapporteur of the world. So therefore, that's one of the main issues that exists. The instruments, I'm very sorry, but everyone uses mobile phones now, smartphones, right? So there's a legal principle throughout the world that says nobody can allegate ignorance before the law. I use this at the moment regarding in the field of human rights. Nobody can allegate ignorance of human rights because everyone have access to this. Right in the palm of our hands now. We can all have access to different instruments of human rights. Read them, and when we have any doubt or concern, we can just ask. So I believe that that's what we should start telling our brothers and sisters that they cannot have access there. Well, if you have any doubt, ask. So there's it's a big issue, I believe. And if indigenous peoples can change, I mean, the terminology, if that terminology, indigenous peoples to indigenous nations, well, United Nations have not the faculty to do this. United Nations has two international agreements of human rights, which mentions on the right of free determination of the people, not of states, not of nations. It's peoples. And it's from there where we take that determination of including indigenous peoples, because Hector's not going to allow me to lie when we start discussing what terminology can actually unite us back then. We used to talk about Native Americans, First Nations, Aborigines, Natives, Indians, well, all the different terminologies. Our elders said, no, indigenous peoples. And well, we took that on, and not native indigenous. Because you remember, Hector, when the Africans came? Oh no, the Afrikaans that created the apartheid in South Africa. They arrived to Geneva to ask us to include them as native people. So Afrikaans, I mean, there's historical issues. I mean, we cannot change these things. Indigenous peoples, it united all of us, all the world, during that time. So very quickly. Doctor, human rights is not a moral commitment, not a legal commitment. It's a legal commitment that the states have of abiding by these and respecting them. Nothing else. No more, nothing more. Morale, because that's why I wrote it down there. It says here, it's a moral responsibility of the states, and they have to be put into practice. No, it's not a commitment or moral commitment. Maybe we can discuss on that later, but it's an obligation of states to comply by these, not even negotiate human rights. You don't negotiate human rights, you respect them, and that's it. And here, I'm very sorry, yesterday and today I was listening to the words of constitutionary rights, or let's stop the constitutionary rights. Please, it's a legal system that each indigenous people have. This is a right which is a discrimination and a racist terminology. It means that the legal systems of indigenous peoples is lesser than the state law. Our legal system has regulations. And that is the reason why we have to call it legal systems, not constitutionary law that is used at an international level. Because in international law, yes, we do recognize that the customs are sources of international law. Of right, sorry. So I believe that that's what we should start to work on right now. That's why yesterday I said, decolonize ourselves. Let's decolonize ourselves. And it's not custom to do this. And now this morning in the summary they said that I had said that it was a custom. No, it's not normal. I'm just saying it's not normal. It's not a custom. It's a legal system with its own regulations, which has dictated us for thousands of years now. Us, we Mayans even. Thank you. Very well. We have reached the end of this last dialogue. Thank you so much for your interventions. Thanking everyone here, all the audience. And so we will now go to the last part of this dialogue. So therefore, I don't know if we have a small break, a short break. No, apparently not. So we will continue because we're short of time. Thank you very much. We'd like to thank you for your comments and your final words. Perspectives are understood of these 2 working days, when there are agreements. There's always the results of interesting dialogue. Now, we give the floor now to Mr. Jan Gerard, Regional Representative of the Office for Southern America for the High Commission of the United Nations for Human Rights, who will share the proposal of lines of action to guarantee right to access of justice for indigenous peoples, developed based on these 2 work days. Mr. Jan, you have the floor, sir. Good afternoon. Thank you very much. I'm going to try to summarize these 2 days of work in 15-20 minutes. And it will be an imperfect effort. Imperfect because not all the intensity of these dialogues can be summarized in a couple of minutes, because it truly is an effort still alive, which as an office, all our collective will continue elaborating. And we will have a worded or written document which will be shared with all of you of our conclusions, and there will be more better worded and much easier to understand. Having said that, allow me to therefore mention some general conclusions, and then afterwards mention some of the subjects discussed here, the main messages that we have been hearing on behalf of yourselves. And then afterwards, we will identify what we have urged collectively as participants of this event before the authorities of the states, and to end with a brief list of commitments amongst ourselves, or commitments which correspond specifically to the High Commission for Human Rights or other institutions, international institutions. Is that okay? Very well. Please be patient. It was about 15 minutes of summary. We had two things: pluralism, judicial, and the response of ordinary systems of justice before the threats which indigenous people suffer, before the growing pressure of business interest, extractive industries, agribusiness, before the criminalization of the defense of the human rights. And it was pretty ambitious to try to join these two topics as part of one event, one dialogue on access of indigenous peoples to the justice system. So the question would be, have we achieved this? And the result, in my opinion, but also confirmed by different organizations with many participants, which mentioned that, they say, yes, we have presentations of excellent quality, we have had a very rich dialogue, a very substantial, on both topics, and we have identified links amongst themselves, or things in common. So it may be that the issue of access to justice, ordinary access and protection within the most broader sense of things, in many parts, eclipsed the topic of pluralism, legal pluralism. It is true, as it was mentioned by Francisco, that we didn't have enough time to analyze all the different systems of indigenous law. We could say that we had needed time to analyze thoroughly the promising sentences that we have during the last couple of years, even though mainly from the Inter-American courts or constitutional or supreme courts of countries. It was mentioned on behalf of the special rapporteur that indigenous peoples continue recurring to the mechanisms of indigenous law due to their geographical proximity and cultural proximity, thereby to these, because the justice can respond to the lack of legal protection from the state, especially in different contexts, where their access to is denied to indigenous peoples as a result of racism and discrimination. Between these dialogues, it was pointed out that apart from the normative progress, indigenous people still face discrimination, racism with it when having access to justice of the state, or ordinary justice. At the same time, some states have mentioned that they don't even recognize indigenous law or justice, and others do recognize a legal pluralism at a legal level, even constitutional. They are pending the coordination between both systems, or there's a gap between what is being recognized at the legal level and constitutional and what truly exists in reality, because the systems of indigenous law is undermined by ordinary justice members. Many of you mentioned that the indigenous justice tends to be less punitive than ordinary justice, to give privilege to solution of restorative justice, and this could be very important and very valuable. Many insisted that we have to decolonize this view of ordinary rights, on a Western view on indigenous justice systems. These are not just customs, as it was mentioned, and nor should they be in rural areas. We're talking about live systems that can be modernized in a context in which more than 50% of the population, indigenous populations, live in urban areas. So it's not just remote areas within the region. Also, there's an increase of threats of defenders of human rights, of indigenous rights, which gave us some very harsh testimonies as the attacks, while the defense of human rights of land and territory are subject to stigma, defamation campaigns, and criminalization, unduly use of penal system to criminalize manifestations and protests. Now we're left with many testimonies, but I'm just going to quote one, which says, if we do not trust the justice system and dialogue with the state, it's not because if not because of experience. We've tried to dialogue with the system, but dialogue is unequal. One day they offer meetings, and the next day they arrest you in the morning and they put you in jail. So very strong words, very strong testimony, not just a whimsical. Some participants mentioned that the courts seem to always decide on cooperative interests, especially extractive cooperatives or industries. Good sentences, or positive sentences from Inter-American Courts of Human Rights have been dictated. It has mentioned the courts of the Caribbean, but also some national courts, special at a higher level of the Supreme Courts and constitutional courts, while at a level of the judges who issue positive sentences in favor of indigenous peoples consider being a very small minority. Positive sentences frequently are not given. In the context of delimitation, demarcation of territories and borders, these suffer a lack of political will here, but there are other obstacles. That the processions of delimitation or demarcation are very demanding, costly, and red tape, very bureaucratic for peoples, and on the orientation of the dominant model, of the Western dominant model, towards the protection of individual protection, private protection, and that collective possession of lands which characterize of indigenous peoples. Governments also many times have little knowledge of where indigenous peoples are located, and before their absence, economic activities are superseded. So authorities usually are not very sensitive, or they deliberately try to restrict the right of indigenous peoples to land and territory in situations where its occupation is intermittent, or where it was interrupted by the expulsion of these peoples through violence, terror, in the interest of industries. And when there is delimitations, it's not enough sometimes. The protection of these territory before extractive industry and criminal invaders as well. So also the practice of some governments has been criticized of establishing protected areas on behalf of defending the environment, but with the intention of forbidding the management of these territories by indigenous peoples, and then they pass over these lands to the companies and industries. There's a counter speech between the penal persecution of indigenous peoples for cutting the tree, but the concessions are given to mega projects freely. Transport and of other mass destruction of the environment. So we know that this dialogue was carried out once preparing the event, the high-level event, which will be celebrated in Geneva by the 75 years of the Universal Declaration of Human Rights. And its results will contribute to also the roadmap of the Office to promote access to justice for indigenous peoples within the region. Please allow me, therefore, to enter the prescriptive dimension of things. It's not definite, so that's where I will quote some of the things that have been mentioned and where we are convinced. There is a lot of consensus on this. It has been mentioned, therefore, to progress on laws which recognize the legal systems of indigenous peoples and their authority, and also a better coordination amongst the systems. To recognize and value the role of indigenous justice for the defense of the territory, and also for other rights with a comprehensive vision, and that this is recognized by the ordinary justice system, to value the contribution of indigenous justice for effective access to justice. We called engagement amongst indigenous peoples and the legal powers, training of operators of justice on matters of intercultural matters, and respect to the indigenous peoples and their culture. We urge to understand the indigenous view of the function of the ordinary justice system, to build a new way of engagement between the indigenous peoples and state institutions as a whole. To perceive indigenous peoples as players with abilities of contributing to the solutions of structural issues and for development. The legal systems of the state are urged to progress also, including indigenous professionals amongst their members, to create programs of training for judges and the elaboration of action protocols which could facilitate, therefore, the mutual recognition and harmonic actions. And we must point out the relevance of the schools of law for the harmonization and interpretation of the law with an intercultural vision based also on international standards. Now, the system of ordinary justice must count with a comprehension of the function of indigenous law or justice, to count with databases of their jurisprudence. Also, it was mentioned that it is necessary that the courts and the public defense can engage with indigenous territories to identify the realities, to get to know these, but also to monitor and follow up these sentences. It has been mentioned that it would be relevant to count with information banks and of best practices compared, something that authorities should do as well, but it may be necessary that we boost these things, or the same indigenous peoples or international mechanisms of human rights. Also, it was emphasized, and very much so, the importance of protecting people, defenders of human rights, indigenous rights, and in this case to investigate and to sanction the attacks against them. It has been mentioned that it is necessary also to investigate the threats, not to wait until these are turned into violent attacks which result in deaths and casualties. We must investigate these attacks, giving privilege to the hypothesis of the reason was the defense of human rights there. To investigate not only the material authors of these attacks and also the intellectual authors, which correspond to all operators of the system of justice, to investigate and to sanction the violations of human rights of people or defenders, or with due diligence and with a differential focus and intercultural focus. Also, it was mentioned that it is fundamental to promote the structure of mechanisms which are solid of protection of people or defenders of human rights, which goes beyond operators of justice. This has to orientate the interinstitutional path with early alerts and risk analysis with a differential character, and consider the total participation of indigenous people within the adoption of measures of protection adequate to their own realities and contexts. But beyond the operators of justice, We urge the states first to care for respect and the positive implementation of the right to consultation with freely and informed, adequate, cultural, and in good faith. So it's mentioned that the participation cannot be reduced just to consultation and consent. Nevertheless, it is time now that the obligations of the states on matters of consultation and previous consent, free and informed, truly should be implemented. Also, to progress on the delimitation or demarcation of lands and indigenous territories and promote the respect to ancestral territories, together with the right of self-determination of indigenous peoples, to understand and to recognize the collective conception of land and centrality of the territory, which is part of the cosmovision and essence of indigenous peoples. Thirdly, to eliminate the use of strength or force in its interaction with indigenous peoples. Fourth, to struggle against the stigma and the discourse of hatred against indigenous peoples and defenders of human rights, indigenous rights. Fifth, to prevent and repair the social structure, the reduction of civic space. Sixth, transversally speaking, always keep in mind the specific needs and demands of women, young people, indigenous young people, indigenous children, which to promote, therefore, actions which may favor them. Seventh, to carry out public policies which include as active subjects people and communities of indigenous peoples, urban currently, and many times forgotten, and to avoid to weaken the interdependence of operators of justice, or that they're captured by economic interest, enticed by them. Ineffective access to justice of indigenous peoples is fundamental. The compliance of responsibilities of companies and industries regarding their operations and throughout their supply chain. This is something which we have been discussing last week, in fact, in another event on companies and human rights, which also counted with participation of indigenous peoples and fighting the environmental crisis. This has to be guided by the principles of environmental justice regarding the rights of indigenous peoples and nature, and to promote its recognition. In fact, it was mentioned that the indigenous practices and traditional knowledge must be considered as an example and a guideline to fight against climate change and its negative effects. And finally, chapter of commitments for us, of our commitments. Well, within these conclusions, common compromise commitments arose to continue making visible and accusing the violations of human rights of indigenous peoples. It was reaffirmed the need to systemize information which can allow to render accounts of all the implications of rights that violations of human rights and barriers to access of justice, inequality, discrimination, racism that persist in this region, to generate evidence also and disseminate these in spaces of public resonance. But at the same time, to go beyond accusations only. It has been mentioned that social protest, indignation is necessary, many times unavoidable, but also we do need constructions of alliances, dialogues with the relevant powers and even with our adversaries. It has been mentioned also the need to harmonize with indigenous peoples to create synergies amongst indigenous movements on one side and the international system of protection of human rights on the other side through the Americas or throughout the Americas, but also all allies amongst the legal powers. For this purpose, it is fundamental to strengthen collective tasks, networks, and resources and funding. To continue insisting on what the international framework already has established, it's important not to accept that the agreements and the international treaties that states will not comply with. We have to continue insisting. These are the tools that we have available. This is our noble architecture at our availability, and we have to continue insisting, and we have to persist and to make operators of justice more sensitive on these topics. On behalf of institutional and international mechanisms of human rights, once again, in strict links with indigenous peoples, the commitments are the following. Through technical cooperation to contribute to the operation of mechanisms or instruments which increase the efficacy of the application of regulations, but also to strengthen the efficacy of the action of indigenous peoples, such as allies, as defenders of their rights. For example, through development of protocols for investigation, systemization of jurisprudence, to share these amongst the practitioners of these fields, to strengthen the capabilities and skills of indigenous peoples, to demand the private and public sector to respect, to protect the human rights of indigenous peoples. So we have to rethink once again the role, our role, and the role of international organizations, because working together with indigenous peoples is fundamental. So we need to accompany the action of indigenous peoples in each country in a more efficient way, on site, regarding all these new and old challenges. So with this purpose, to promote strategic litigation, monitoring of the application of guidelines, and generate cooperation which can create the public debate to implement a new way of being in the territory, accompanying the indigenous people closely. It's a huge challenge, but necessary. So we work together with the indigenous peoples, and it is necessary that this rapport can deepen even more so. And to build on, to deepen this rapport, this relation, it's vital to get to know the reality of indigenous peoples currently, its cultural transformations, to understand their internal changes, to synthesize and to align ourselves with their aspirations and realities. We value highly the role of mechanisms, or international mechanisms and regional mechanisms regarding the rights of indigenous peoples, but we also need to identify on our behalf direct ways which can allow a correct and more efficient reaction independently of the invitation from states. Finally, the shared experiences lead us to mention that it is important to react, on one hand, from the richness of the community, and on the other hand, to generate alliances to accompany permanently and to revert situations of lack of recognition, attacks and risks, and the lack of protection within the territory. Thank you very much for your attention. Thank you very much. This is a document that takes fundamental elements which surely was allow us to continue of having access to justice on the behalf of our indigenous people. So we're reaching the final part now. I'd like to therefore invite Miss Nancy Yañez. She is Chair Lady of the Constitutional Tribunal of Chile, and Alberto Brunori. He's regional representative for Central America of the Office of the High Commission of the United Nations for the Human Rights. Please, if you could come up to stage here to hear your words of closure of this such important event. Thank you. Nancy, you have the floor, please. Well, thank you very much. I'd like to thank the High Commission of Human Rights for this invitation, but especially due to the opportunity of being here in this roundtable, greeting you all and sharing with you experiences once again with our dear friends, leaders of indigenous populations and indigenous people, which I've had the great opportunity of accompanying through different paths in the seeking and guaranteeing indigenous rights within our continent. So thank you very much for this invitation. I'd like to start off just reflecting on from the point of view of constitutional recognition here. It is relevant when we talk about the rights of indigenous people and access to justice to see how the forms of how this recognition has been given different constitutional processes in our continent, and of course this will be make visible the gaps which are observed in Chile specifically. I want to do this starting from 4 constitutions which somehow show us stages in the constitutional debate of the region. The 2 first is the Constitution of Colombia, 1991, Peru, 1994. A perspective of compared rights allows us to verify the right of access to justice from 2 points of view. One is recognition of the indigenous justice system and the way through constitutional models recognize indigenous justice, and the catalogue of fundamental rights regarding the integration of the indigenous rights recognized through the international instruments in matters of human rights. So if you read the Constitution of Colombia since 1991, as you well know, those who come from Colombia, for example, recognize the authorities of indigenous peoples. They recognize the possibility of exert jurisprudence within the territorial environment according to their own procedures and regulations, and regarding the environment of matters on which indigenous law can be actioned within the previous constitutions to this reform. And then it mentions that rights and duties within this chart will be interpreted regarding the international treaties on human rights. So this allows that in the legal resolutions, the courts of law can collect the international treaties as an interpretation which strengthens the catalogue of rights. Now, the Constitution of Peru will not have the particularity that it will include indigenous peoples, so we can observe how the constitutional recognition is not only permanent for legal pluralism, but also for the dynamism that indigenous systems have as all social entities. Regarding the incorporation of the international treaties in matters of human rights, we do have an innovation in the constitutional text of Peru, because it mentions that regulations will be interpreted regarding the Universal Declaration of Human Rights and the treaties and international agreements on the same matter. So here we could say that remission to the declaration is a remission to a regulation that, even though it's not within a conventional instrument, it is considered as a regulation that they choose, a right which obliges everyone who make up the international community. So if we go to the second stage of constitutional recognitions, not the multicultural constitutions which gather all their structure in the recognition of collective rights and differentiate subjects who are the indigenous peoples, then we enter the constitutions of Ecuador and Bolivia, who have structural changes of state, so gives notion of this national state which has structured our own republican status. I'd like to mention that in the Constitution of Ecuador, also this dynamism to which has been referred to, but in particular the human rights at an international level and internationally recognized as factor of legitimacy, which is democratic of institutions of government, including the inclusion of indigenous law within the exercise of its own legal powers. But here is another interesting element, which is the movement of indigenous women regarding their competence within their territories, with guarantees of participating and decision making from women. So therefore, we observe how the traditional system of indigenous justice is permeated by the reivindication of the movement of women, but seeks to redefine themselves in the structurally of their own society. Now, the Constitution of Bolivia innovates especially on the area of exercise of indigenous and farming powers. If not, we're talking about what has strengthened the authority of the decisions that institutions take, the peoples and indigenous peoples make. So I imagine that you already have been able to understand how the law of legal unbinding is restricts these issues. Nevertheless, I believe it's important to point out the commitment that state institutions assume with the effective fulfillment of the decisions from authorities, indigenous authorities, in coordination and cooperation with other legal, ordinary authorities such as constitutional jurisdiction, which strengthens the legitimacy of indigenous societies. So I believe that is relevant because we observe that this constitutional discussion here is pretty old in our region. It's part of strengthening the democratic institution in the democratic transition post-dictatorship and decolonization within our continent, which has been going on throughout the whole republic. Which has given importance, which means that all constitutional texts, with the exception of the Chilean and Uruguay constitution, recognize the existence of indigenous peoples, so therefore diversity of the political community in question, which does not occur in these countries, or does not occur in Chile. So therefore, within the constitutional process here, the political community of Chile is surprised when there's debate on pluralism, or legal pluralism that we can observe is present on the basis of the constitutional debate on recognition here. Another important point that I want to mention is regarding the international rights and the application of internal law, because this consolidates the statutes of rights to which jurisdictions are exerted. But it has particular relevance also where the system of indigenous justice are not recognized, and it's the state justice which is in charge of safeguarding, within the context of human rights at an international level, the rights of indigenous people. So when we talk about access to justice, there is a debate regarding the sources of international rights and its application within internal rights. So therefore we go from internal law. So we go from institutional frameworks where only the conventional instruments are recognized, ratified and in force as interpretative sort of regulation of the constitutional text. Those constitutions, for example, in the case of Peruvian, it resolves it there. It says we will be understood, incorporated with quorum, those who correspond normally to a constitutional reform, and therefore it integrates the block of constitutionality there. This is relevant not only on the Agreement 169, but also regarding all the other instruments, or international instruments on matters of human rights, to which the interpretation has been carried out on the rights of indigenous peoples, which allows us to generate, therefore, what the Inter-American Court has called Corpus Juris Internationale, Corpus Juris International, which renders account, which also allows to incorporate jurisprudence, which is can be interpreted by the supervision organizations who have the authentic interpretation of the instruments or are in charge of these, based on the interpretation that the Inter-American Courts of Human Rights has carried out within the American Convention of Human Rights. On this line, two more things to reflect on, and its importance within the legal rationale for guaranteeing indigenous rights. First is the relevance of broadening this conception of block of constitutionality. So the constitutional text, therefore, can integrate itself not only by conventional instruments, if not by conventional treaties, and also by international instruments, which will allow, therefore, effectively to bring forth the legal interpretation within the internal law, the Universal Declaration of the United Nations on the rights of American indigenous peoples and the rights by the Inter-American Commission, and what I have referred to also, which has been broadly applied by the Inter-American courts. Another point which is under discussion at the same time, there's no consensus, of course, within the internal doctrine on this broader notion of what is constitutionality, but I want to mention its relevance on safeguarding the security of indigenous peoples, the rights of positive conception, which to restrict the environment of rights internally. What's the idea of confidentiality and the relevance of this within public rationale? This was important because it was coined by the Inter-American case that involved Chile. It implies in an international context the Inter-American courts on the supremacy on the American Convention of Human Rights.
But in the internal environment, that is the one that performs the agents of the state when doing compatibility of the norms and access of internal rights with the obligations of the state. And so this idea is specifically the one that places in the discussion the progressivity of the application of the law, international law of human rights in the environment, internal environment, and it allows us to generate a conception of multiple level protection in which human rights play a double regulatory source, the one for national rights and the one that provides international law to which judges, men and women, can modify and use when interpreting rights and obligations coming from the state. So in the Chilean case, and I make this reference because I do wish to share with you some elements on what that I think are relevant in the last development of the Inter-American System for Human Rights, but specifically how these norms receive or not an application here in Chile today, with the restrictions of the recognition and with the constitutionality block that is more related to a weak or restricted conception. In our country, Article 5, the second part of the Constitution in the Republic, establishes that the instruments, international instruments in terms of human rights ratified by Chile and current, constitute a limit to the execution of sovereignty of the state, right? And the issue then that has been stated is what it means, limit to sovereignty of the state. We need to understand that they are not available in a prominent interpretation, which is the one related to the international laws for the human rights that are not available for the constituent or the legal powers. Therefore, what they want is to have regressions in the regulation of these matters in the specific country. What has been pointed out, or better yet, what are the problems stated by the application of Article 5, the second part of the Constitution in Chile, and might be illustrative. Hopefully, it is not similar to the reality of other countries in the region. But here you can see the half of the glass empty or full. So let's go to what the Constitutional Court has said about the legal state of Convention 169 in the jurisprudence of the Constitutional Court. When the Constitutional Court has had to speak about the legal status of international treaties, and especially regarding Convention 169, has pointed out that the Constitution, the Chilean Constitution, has not indicated specifically what is the normative rank on international treaties. Not even with this are related about essential rights of the human nature. You can understand that in all cases they have a lower rank to the Constitution when submitted to preventive control that is mandatory, when they are related to issues specific about the constitutional organic law, therefore require for a control. They require control in the parliament of a higher quorum. A higher quorum, it is the only moment when a treaty is submitted to constitutionality control that is prevented with the Constitutional Court. That actually happened with Convention 169, and it's important to highlight that Convention 169 was adopted in Chile with reform quorum, with constitutional reform, 4/7. So it does comply with the maximum standard for its incorporation on internal law. The legitimacy test, democratic test, was passed completely and debated 15 years in the parliament. However, when determining the legal status, it is not mentioned the incidence that this norm, what it means in definitive. The limit to sovereignty seems to be that does not have enough content when there's no explicit pronouncement in this topic. And this is permanent, persistent, always debated when applying international norms to interpret the constitutional norms. And we'll see that the jurisprudence has moved, not specifying about the source concept, but incorporating these norms in terms of interpretation by generating some very interesting jurisprudence that we should share. Now, the situation generates problems. Convention 169 was estimated. In Chile was coined a conception of the self-executability of the treaty. Therefore, it was self-executable, the norms of Article 6 and 7 on topics related to the consultation process, but not the rest of the convention. And that has meant that when you call upon the convention for safeguarding of fundamental rights, this debate that it is a tool of not of a constitutional rank, but infra-constitutional rank, comes by generating problems in warranties of access to justice. And I wish to share a case, a member of the council, a person that chooses a position of popular election, elected by necessary majority, actually with the first majority, but the organic law from the municipalities that has organic rank, constitutional organic rank, so it is part of the block of constitutionality, makes available to avoid nepotism in the execution of the political power that needs to renounce the one that is elected in a municipality where the mayor or any other member of the council, the mayor is a direct relative, something that is specifically difficult in territory with a wide representation of indigenous communities, and usually respond to indigenous communities that share the same lineage and also execute leadership, traditional leadership. So it is reasonable, coming from the logics epistemological of indigenous people, from their political demands, that these leaders should be the ones that represent the community interest in whatever instance it belongs to. But now we observe that the court rejects their requirement because they deem that the municipality law has more legal rank than Convention 169. So that is the problem. What is the status of the source, which seems to be key? Another case that I think is the most new, which is the inconstitutionality of the Pascal law. And with this I will finish. I think I have taken a huge amount of time. The Constitutional Court, back in 2020, I was not in the Constitutional Tribunal, so it's a merit, complete merit of those forming the Constitutional Court in that opportunity, where you can say that not necessarily you didn't have experts in matters of the rights of indigenous people. Now, the Pascual Law is a law from 1966. It is a law adopted. Well, it is the first law that regulates a citizen statute in Rapa Nui. Until 1966, Rapa Nui people this was a territory attached to Chile without having the benefit of a citizenship letter or nationality. The territory was landed to international companies, or better yet, controlled by the Chilean army, but without the recognition of civil institutions or right or law for Rapa Nui. I think it's relevant because it shows what we are in a debate that finally it is a decolonization type of debate, not only for the case of Rapa Nui, but also for the rest of the indigenous people, that since they don't enter through the statute of decolonization from the United Nations, in the end, they find this statute of human rights of indigenous people. They find the mechanism through which they seek to compatibilize their rights with the democratic states on the basis of the full respect of originary people, of course. So in such opportunities, it's been established some special norms in the criminal environment when thinking about Rapa Nui that decrease the penal responsibility, including this decrease not only in crimes related to property, but also crimes against sexual integrity. According to these norms, crimes against sexual crimes, it decreases them so much that allows for 2/3 of the criminality in case of violation, sexual harassment, non-consensual sexual abuse, harassment, and so on. Finally, they can comply with only 1/3 of the criminality and 2/3 in freedom. Now, the basis of the legislator to adopt this back in 1966 were the Polynesian customs of the Rapa Nui Association, more liberal in the environment of sexual relationships, that in definitive caused to estimate that this finally justifies a decrease of penalties and crimes that is related to the autonomy of women and not cultural practices. So the tribunal deemed that it was not a case of constitutionary right, but the imposition of criteria on behalf of the state without the participation of indigenous people, without thinking, considering their cosmovision. And it's quite interesting because it questioned the lack of participation. It's a historical issue coming from the 60s decade. And I will read what the tribunal says about that, which I believe is interesting. It says there's no participation of any native or from Eastern Island or authority on their side or academic with any knowledge with knowledge. So in summary, the extent law of the law reveals that the legislator has developed a group of criminal benefits and the execution of the penalty based on generic criteria regarding which there's no reference on the type of sexual crime that is present in this case. The only reference is constitutionary right, not connected to a notion that overcomes the dimension that seems specific to the environment of rights against property. The tribunal says this systematic notion of a legislation with decisions that seems to be founded in an ancestral dimension, but it's not possible to sustain for the legislation to have collected a tradition or a custom. This case was presented by the judge from Rapa Nui, seconded with amicus by women, the women's organization from Rapa Nui that talks about the importance of the women's movement in the constitutional recognition from Ecuador, and how this can also have an incidence for an effective recognition of rights, and it was applied. Convention 169 was applied, indicating that even though Convention 169 must favor criminal sanctions different to incarceration, this can jeopardize fundamental rights of people, such as sexual safety of women. And today we have collected systematically international law and human rights based on Article 5th, the second paragraph, following this open path with this sentence. And even though it doesn't involve issues related to indigenous people, right, I do want to make a reference to a sentence, 12,274/21, where the Constitutional Court collects the focus of intersectionality in order to waive the existence of discrimination and specificity of this discrimination due to the convergence of different factors. So here, the Constitutional Tribunal not only collects the inter-American practice, but also the practice of ordinary courts of justice, especially the Supreme Court case, that is a case that involves an indigenous woman, the Lorenza Cayuan case, in the framework of the Mapuche conflict, was being processed and was deemed dangerous because was part of the movement, and so was moved to give birth in a clinic and assistance, and was incarcerated until the doctor in charge demanded to remove these chains. But the people from the police officers was kept inside the place until there was the birth of the daughter of Miss Lorenza. And here the Supreme Court has determined that here we have a paradigmatic case of intersectionality that has been expressed in factors that are crossed with discrimination impotence, and they have a negative impact in the protected person, which is an unfair treatment, migratory treatment, because of the case of a woman that was about to give birth, belonging to the Mapuche ethnicity, and unnecessarily jeopardize her health and life, and also the life of his son. All of that for the national and international regulation in this matter. So with this, I will conclude my presentation, specifying that still in countries where we are, we still need some recognition processes. Today, we do not see how the safeguarding in indigenous rights in the legal area can become concrete through this harmonic connection between international law and national law that allows us to move forward despite adversities. And so that's it. Thank you so much. Good afternoon, everybody, all of you present in this dialogue that for 2 days has been very important, a crucial dialogue and never seen before, a regional dialogue in Americas with indigenous people and access to justice. I've been here 2 days together, giving specific steps to the creation of a collaborative space where the core of the discussion is to promote, protect, and guarantee the full execution of human rights, emphasizing equal access of indigenous people. This year, we've heard, we've seen, it's been said by the High Commission, frames 75th anniversary of the Universal Declaration for Human Rights. And in this context, our head, Volker Tulk, makes us reinforce our commitment to these universal principles. When dealing with global current challenges, it is key for us to reflect on the relevance and how important is each right proclaimed in the declaration. This dialogue of the strategies that have been presented do reflect the collective effort in that renovation of the commitment. It is a journey we take with the wisdom acquired in what we've done right, but also past learnings and also the things we haven't done so well. After 2 days of profound analysis, debates, a concept emerges strongly, and I would like to highlight, which is the recognition. Along the last decades, we have observed progress, meaningful progress, in the recognition and strengthening of the rights of indigenous people on a global level. So from the adoption of Convention 169 of ILO and the Declaration of the United Nations on the Rights of Indigenous People, the legal international framework has evolved in favor of protecting and promoting their fundamental rights. These documents, together with the constant struggle of indigenous communities, have promoted a legal change and public policies in different countries. As a result, many nations have started to recognize their language, tradition, ancestral lands, form of government, and justice. However, despite these events and advances, we still have challenges that are meaningful, such as discrimination, criminalization, conflicts for natural resources, as we've heard in all the sessions that we have been a part of and that we have been debating. It is imperative that the knowledge to transcend and finishes in equal, fair, dignifying treatment for indigenous people in all the region. To understand the nature of indigenous rights is a key. It is not a static system, but dynamic, adaptive, and resilient. Has thrived along the challenges of history, including during the dictatorship in this part of the continent, or during the armed conflict with Guatemala, for instance, has lasted and thrived along the challenges of history, was said, by proving to be not only a group of laws, but a cultural social process. We can't or should not separate indigenous right from the essence of our communities and their lands. The strategies proposed in this meeting are not only an opportunity, but a responsibility, a shared responsibility. In the 75th anniversary, the Office from the United Nations for Human Rights wishes to restate that working and for the indigenous people is a priority that cannot be broken. We will continue to back up and promoting initiatives such as this, always searching for the well-being of the rights of indigenous people. The path is long, but no one can stop us if we walk with the light and in the light of the declaration and the different instruments, international instruments. I would like to express my deep recognition and thanks to all participants, especially indigenous authorities joining us, the representatives from the state officers, government officers, members of the parliament, academics, advocates, and defenders of human rights. To conclude, I would like to thank Chile for her hospitality, the team of the High Commission Office from the United Nations for Human Rights on the region of Americas, and especially the colleagues from the Regional Office for America from the South that have done a wonderful work. So, and also my team in Panama, the scholars, senior scholars, indigenous senior scholars, for making this encounter, this meeting possible, which has been so important for this whole region. And finally, I would like to especially thank on behalf of John, to Rapporteur and friend Francisco Calin for joining us along this effort. Thank you so much.
We'd like to thank you very much for your contributions, important contributions, your reflections with these closing words. Please, we invite you now to be seated so we can continue with something that we have begun this morning. As we have initiated with a ritual celebration of this fora, we will end it in the same way. So therefore, I invite our sister Isabel Godoy of the Coria of Chile and our brother Zenobio Fernandez of the Caracada Nation of Bolivia. Good afternoon. Those who were with the inaugurational ceremony remember that we invited some of you to have this sacred circle as a symbol of commitment. This task which we were, or this task, this endeavor. So therefore we will request the same people who I will name now so they can come up and untie this knot, and we will tie it back on their wrists so they can take it back home with all our blessings that we have brought before this marvelous summit or conference. To thank my ancestors for allowing me to be here, survivor of the genocide of the Spanish invasion and the dictatorship that happened in the 70s, 1973 here in Chile. Personally, I'm a survivor of this dictatorship. I'm a former political prisoner. During 15 years, I'm an activist for the rights, human rights of my country and my indigenous people. So having said this, I invite also Francisco, Mr. John Derek, Ms. Sarah Lopez, Carmela Guru, and Darling Garcia. I'm sorry if I didn't pronounce your names properly. The important thing here is what symbolizes these wristbands. I will start off. I'm sorry, I can't hear very well without the microphone. Very well, so continuing, on behalf of everyone present here, I would like to thank your hospitality of our brother country Chile and all our indigenous brothers and sisters who live in these lands. So I'd like to thank also the regional representatives for Latin America or the High Commission of the United Nations, and our brother Francisco, Rapporteur, Indigenous Peoples of the United Nations as well, authorities, legal authorities of ordinary justice and indigenous justice, constitutional authorities, Dr. Nancy Yanez, Chair Lady of the Constitutional Chamber of Chile, Petronilo Flores, magistrates of the Constitutional Courts of Bolivia, defenders of indigenous rights and rights of the Mother Earth. Brothers and sisters, if you just allow me to shortly give some reflections about this event, and what I'm taking back with me to my country is the following. Justice is the constant will of seeking the welfare of all human beings and indigenous peoples and our Mother Earth. It's a right to resist all types of oppression and to use mechanisms which correspond in extreme cases, to use their own mechanisms, defending their ways of life. Indigenous peoples, we must practice solidarity, independent of the state where we may find ourselves. We must raise our voice of solidarity before the international community in favor of brothers and sisters, peoples who suffer violations of human rights, because we all are reason of existence and the struggle of our forefathers from which we have inherited this territory, and also the struggle that we have to maintain these lands, which is the habitat of our people. In this sense, therefore, brothers and sisters, I would like to thank, and also, as is tradition in our people, it is all transitional. Everything's transitional. So this event does not end here. I will declare it like a fourth intermediate, or just a pause for this to continue, this event to continue. Never rest seeking justice of all of us, brothers and sisters, as a society, as indigenous peoples, and maybe abiding to a mandate of a son of a carpenter said, love thyself and others. Let's practice this. So in this sense, I would like to pause, a fourth pause for this event, this new opportunity therefore, and let us leave with this force and transfer and convey this to our governments, our peoples, all the tasks that we have done. Ay, ay. Thank you. So anyone goes back home safe and sound to your families. Thank you very much. Thank you very much to all our authorities of indigenous peoples. We'd like to please right now, if you could just remain, and ask you to remain in your seats. I would like to communicate the closure of the broadcast and to ask the team to project, therefore, with a QR code, the assessment or the evaluation of this event. We request you please